On behalf of Boston University Law Review Online, welcome and thank you for coming to the Advancing Pregnant Persons' Right to Life Symposium. My name is Sam Bates-Norum, one of the two editors of the Boston University Law Review Online, along with the incomparable Jamie Francis, and we both would like to thank the editor-in-chief of the Law Review, Keenan Hunt-Stone, the senior managing editor, Carolyn Grady, and the Law Review faculty advisor, Professor James Fleming, for their guidance and support. Boston University Law Review has a long and storied history, printing its first edition over a century ago. Its online version has been around only a little less time than that. But the legal works, policy proposals, and academic comments that we publish are no less important to shaping the discussions and perspectives of the legal community. To that end, we would also like to thank the co-directors of the Boston University Program on Reproductive Justice, Aziza Ahmed, Nicole Huberfeld, and Linda McLean, all professors here at Boston University, for their work in organizing the symposium and trusting BU Law Review Online to host a wealth of knowledge that will flow from this event. We are also grateful for the co-sponsorship by the Center for Reproductive Rights and Northeastern's University Center for Health Policy and Law. We are now happy to introduce Maureen Butt, Managing Director of the Center for Health Policy and Law. Thank you.
Hi, everyone. Welcome to the Advancing Pregnant Persons' Right to Life Symposium. My name is Maureen Budd, and I'm the Managing Director of the Center for Health Policy at Law at Northeastern University School of Law. We are honored to co-sponsor the symposium today with BU Program on Reproductive Justice and the Center for Reproductive Rights. Previously to coming to Chippewa, I was the Associate Director of Policy and Government Affairs at Planned Parenthood League of Massachusetts, just down the street. While there in 2021, Massachusetts passed the Roe Act, a law that improved access to affordable abortion by removing unnecessary, burdensome provisions that delay and deny care. While we predicted Dobbs would overturn Roe on the federal level, we were in Massachusetts, we were prepared. The legislature and the administration passed more laws in 2022 to shield providers, patients, pharmacists, and people who help others access abortion from professional licensure consequences and the reach of out-of-state investigation and legal actions. But not all people were as fortunate as those living in Massachusetts. Since Dobbs, 21 states have imposed abortion bans, including 14 states that banned abortion outright and 2 others that have imposed restrictions at various points in pregnancy with no exceptions for rape or incest. We are all here today because we understand that the banning of abortion is a public health issue, intersecting with constitutional law and human rights. Wendy Permet, the faculty director at Chippewa, and myself know the important conversations that will happen at today's symposium. Before I introduce the first panel, I do want to make a personal plea. I also just want to introduce Representative Lindsay Sabadosa, who worked on the Roe Act and works on protecting abortion access at the State House. And so I would not be good at my job working on health policy by not reminding everyone that the way that we protect these rights is by voting and electing like-minded people. So everyone, this is your call to register to vote, bring 5 friends to the polling places, because the way we're going to protect these is at a local level. That's just wearing my policy hat. I will now like to introduce Diana Caston and Martha Davis for the first panel. Diana is the Director of Judicial Strategy at the Center for Reproductive Rights and a longtime advocate for reproductive justice and freedom. And Martha is University Distinguished Professor at Northeastern School of Law, where she teaches human rights and constitutional law. Thank you.
Okay, thanks so much, Maureen, for that introduction, and to my colleagues here at BU and elsewhere that have worked on pulling this program together, and I appreciate the opportunity to set the stage for today's discussion. Because the phrase right to life has become so identified with the anti-abortion movement, our title, Advancing Pregnant Persons' Right to Life, seems provocative. It seems daring to even suggest that a right to life could be asserted by pregnant people. So implicit in the title is really the question and challenge: can the right to life be reclaimed for the benefit of living born people, particularly those who are pregnant? And though I'll generally refer here to pregnant people, we know that statistically pregnant people are mostly women. That's a fact that's not irrelevant to the dynamics of the Dobbs decision and the post-Dobbs developments. As Professor Mary Ziegler has chronicled, and as I know from my own research on welfare rights, in the mid-20th century, the idea of a right to life or a right to live was identified with claims against the government for the right to basic subsistence benefits, welfare, housing, food. And this earlier frame of the right to life is consistent with even earlier understandings that were familiar to our national founders, that derived from Magna Carta and address the government's set of obligations to its citizens. Anti-abortion activists have co-opted the phrase, but that is just a very successful branding exercise. It's the historic understanding about rights of living people that's referenced in constitutional language, specifically the right to life protected in federal and state due process clauses, and the inalienable right to life that so many state constitutions articulate and protect. As we'll hear from some of the speakers today, and as you can see in the annotated bibliography that we distributed as background to the symposium, these constitutional protections for life spell out government obligations to protect the lives of persons born. Importantly, historically, these words were also understood as not only protecting lives. The right to life also referred to individuals' broader capacities, including health, well-being, dignity, even happiness. And these obligations included not only substantive rights, but also procedures that could clearly only be enjoyed by living, born persons. Many legal scholars and jurists might stop short of finding that constitutional language establishes affirmative obligations of government to ensure this broad collection of benefits, such as life, health, and well-being. And indeed, the welfare rights movement foundered on that proposition when courts by and large refused to find an affirmative right to live or right to life enforceable against the government. And in 1984, in DeShaney versus Winnebago, the US Supreme Court endorsed the idea that the federal Constitution does not place affirmative obligations on government to ensure realization of such rights, even in extreme circumstances of government control and individual reliance. So government inaction is not a rights violation, the court concluded. But as you know, state constitutions have different texts, and many of them seem to make different commitments. We've seen that in the abortion arena, for instance, in New Mexico some years ago, and now Pennsylvania, where courts and individual judges have found positive obligations to provide government-funded abortions to low-income individuals. And pertinent to the situation now facing pregnant persons after Dobbs, surely proactive government interventions that compromise lives, that steal health, and that undermine dignity and happiness should be held to the highest standard of scrutiny, or if not simply barred altogether. This is not government inaction, but government action, restricting individuals' personal choices about life and health. Diana will be speaking about some of the on-the-ground circumstances where these life and health issues are now being played out, sometimes with very little official recognition of the impact on the lives and health of pregnant people. But before we turn to those examples, I want to spend some time highlighting the legal backdrop provided by international human rights law, which also encompasses a right to life. And that's one of the things that will be talked about during the subsequent panels as well. The idea on the table here today of more fully exploring the meaning of life under federal and state constitutions takes inspiration from the development of this right in international human rights law. The right to life appears in Article 3 of the Foundational Universal Declaration of Human Rights, which provides that, quote, everyone has a right to life, liberty, and security of person. Under international law, these rights extend only to persons born. The International Covenant on Civil and Political Rights, or the ICCPR, is a widely adopted treaty to which even the US is a party. It also recognizes a right to life in Article 6 of its text. The ICCPR is administered by the UN Human Rights Committee. That treaty body is composed of 18 human rights experts from member countries. 5 years ago, in 2019, the UN Human Rights Committee adopted General Comment 36, interpreting Article 6 of the ICCPR to include access to reproductive health care as a component of the right to life. And I'll read a bit of that pertinent language. It's in paragraph 8 of that general comment. It says, all those states parties may adopt measures designed to regulate, so regulation is okay, voluntary termination of pregnancy. These measures must not result in violation of the right to life of a pregnant woman or girl or her other rights under the covenant. Thus, restrictions on the ability of women or girls to seek abortion must not, among other things, jeopardize their lives, subject them to physical or mental pain or suffering, discriminate against them, or arbitrarily interfere with their privacy. States parties must provide safe, legal, and effective access to abortion where life and health of the pregnant woman or girl is at risk, or where carrying a pregnancy to term would cause the pregnant woman or girl substantial pain or suffering, most notably when the pregnancy is the result of rape or incest, or where the pregnancy is not viable. In addition, states parties may not regulate pregnancy or abortion in a manner that runs contrary to their duty to ensure that women and girls do not have to resort to unsafe abortions, and they should revise their abortion laws accordingly. And the general comment goes on with some additional specifics. So general comments are not binding law. They're, have persuasive value. And this particular general comment sparked controversy from countries like Poland and Malta, but it reflects the considered views of the members of the UN Human Rights Committee. Each paragraph of the general comment is adopted by consensus, so, which of course gives it some additional weight. Just a few months ago, when reviewing the U.S. for its compliance with its treaty obligations under the ICCPR, the UN Rights Committee expressed alarm at the increase in barriers and practices that impede women's access to safe and legal abortions in the United States. The committee expressed deep concern regarding this is UN talk, right? Expressed deep concern regarding the impact of these measures on individual rights, including the rights to life, to privacy, and not to be subjected to cruel and degrading treatment, and in particular, at the disproportionate impact on women and girls with low incomes and from vulnerable groups, those living in rural areas and those belonging to racial and ethnic minorities. Not concerned with abortion alone, the committee also noted the high maternal mortality rates in the United States and restrictions on midwifery, the compound difficulties of finding culturally appropriate care. So on the international level, there are respected interpretations of the right to life that recognize the range of harmful, rights-violating impacts of current U.S. abortion restrictions on pregnant people. And I'll add that there's a growing recognition of the relationship between reproductive rights and democracy as well, with restrictions on abortion often going hand in hand with democratic backsliding, which is another issue that I think will come up in a later panel. However, the UN Human Rights Committee interpretation of the right to life to include health and privacy in the context of abortion stands in contrast to current U.S. jurisprudence, which has largely limited discussion of the right to life of persons born to issues of physiological life, whether one is breathing or literally alive. U.S. courts have seldom examined the impact on a person's right to life, as opposed to the liberty right, when someone is unsafe or cannot access needed health care or is in pain or has diminished privacy or personal autonomy. So the question on the table for this symposium is whether and how U.S. law might draw more from the inspiration of human rights law to reclaim this broader right to life for pregnant persons. At the very least, surely the government cannot actively stand in the way of pregnant persons' efforts to protect their own life and health independently without recourse to the government, seeking abortions from private providers, for example. But maybe here today we have the luxury of thinking bigger too, and questioning whether, as some of the justices in Pennsylvania just opined last week, the government is required to do more and to act affirmatively to protect lives and the health of pregnant people. On the one hand, this seems quite pie in the sky, just a short while after the reversal of Roe and the jettisoning of nearly 50 years of jurisprudence under the Liberty Clause. On the other hand, the broader protections of the right to life are, I believe, supported by both originalist understandings and constitutional text. The annotated bibliography demonstrates that those protections have been largely unexamined while Roe was in place. They were secured by the Liberty Clause. And some presenters will be speaking today as well about other under-examined protections, including the First and 13th Amendments. So today we have the opportunity to think about how to theorize these meanings, as well as to consider how and whether we can implement them to advance the rights of pregnant persons. And with that, I'm going to turn it over to Diana to give her thoughts as a legal strategist and practitioner. Thank you.
Is my mic on? Yep. Okay. Thank you, Martha. I want to add my thanks, of course. So on behalf of the Center for Reproductive Rights, I really want to express my deep appreciation to Boston University Law Review and the Program on Reproductive Justice, as well as Northeastern Center for Health and Policy and Law, for organizing this symposium today. The center is truly honored to be a co-sponsor and to have the opportunity to help set the table for this important set of discussions. So as Professor Davis remarked, this is an opportunity to theorize the meaning of the constitutional and human rights protections for pregnant persons. Of course, to do this, it's vital to keep in mind the real-world impact of recent changes in the law, particularly the Dobbs decision on pregnant people's lives, health, dignity, and really all aspects of the course of life. So today, tens of millions of people live in a state where abortion is banned or nearly so. As was true before Dobbs, bans and restrictions hit people living in the South and Midwest hardest and disproportionately impact pregnant people who already face systemic discrimination, including people of color, low-income people, young people, immigrants, and people with disabilities. Now, in the wake of Dobbs, not only is abortion criminalized in roughly half the states and legally unavailable in 14, as a result, these communities are also losing access to trusted health care providers. When clinics shut down, so does a broader reproductive health network. The providers that people relied on for a whole range of health needs, wellness checks, preventative care, birth control, gender-affirming care, comprehensive pregnancy care, and more are gone in some of these communities. And as more OBGYNs leave the state, states where the standard of care is criminalized, maternity care deserts are increasing. So this assault on abortion and reproductive health care more broadly is further compounding an already untenable maternal health crisis in this country. Not only does the United States have the highest maternal mortality ratio among wealthy countries, maternal mortality has been on the rise in recent years, and it is worse for people of color. Black and Indigenous women are 2 to 3 times more likely to die of pregnancy-related causes than white women. So in short, in the post-Dobbs legal landscape, states are forcing people to be pregnant and birth even as our country fails to make pregnancy and childbirth safer. So we do, as Martha suggested, need to think big. It's not enough to theorize how we can build back the right to abortion in isolation. That's why at the center, we seek to advance reproductive rights as human rights and to secure constitutional protections for all aspects of bodily and reproductive autonomy and health, including maternal health, assisted reproduction, contraception, abortion, and more. Of course, in the wake of Dobbs, building back protection for abortion in particular is an especially urgent part of this work right now, both for people who do not want to be pregnant and for people who want to have children. Nearly 2 years after Dobbs, the dire impact of abortion bans for all pregnant people is evident. As researchers and journalists have documented in studies, reports, and personal stories from providers and patients alike, people facing severe, life-threatening conditions during pregnancy are unable to access the abortion care they need. Perhaps most widely reported was the tragic experience of one of the center's clients, Kate Cox in Texas. Kate was devastated when she received the diagnosis that her fetus could not survive. She was further traumatized when she could not get the care she needed at home, and Texas officials literally forced her to flee the state to get the abortion care necessary to preserve her own health and her future fertility. Kate wanted to have more children. Her story and so many others like hers confirm what we have already known, always known. So-called medical exceptions to abortion bans are not meant to work. And as more and more people begin to understand this, they are asking, what about the pregnant person's right to life? If the right to life means anything, how can states justify criminalizing abortion in cases where life, health, fertility, and more are on the line? So, sticking to this. So these questions are at the heart of several cases we are now litigating at the center. In 4 different states with complete bans, we're asking courts to recognize that so-called medical exceptions do not work, to recognize that criminal abortion bans are preventing pregnant people from receiving care necessary to preserve their life, their health, and their fertility. And especially relevant to the topic of today's symposium, we are arguing that these abortion bans violate the pregnant people's constitutional right to life. So as a legal matter, this argument is somewhat novel. As Professor Davis discussed, in contrast to international and human rights law, the meaning and scope of the constitutional right to life is highly under-theorized in US law. To be specific, the US Supreme Court has not directly held that the 14th Amendment's right to life provision limits government interference in decisions about pregnancy. And while abortion cases, including Roe itself, address the substantial risks pregnancy poses to a person's health and life, those earlier decisions do not consider the question of what the constitutional right to life means. They don't provide a legal test or framework for a right to life challenge to state interference in decisions in healthcare related to fertility, pregnancy, childbirth, or beyond. So with this in mind, I'd like to highlight some of the post-Dobbs court decisions and pending cases that might inform an emerging jurisprudence on the right to life. I think as everyone here knows, immediately after Dobbs came down, it created fear, it created legal chaos, and dozens of emergency cases were filed to delay bans from going into effect for the most part. It was about a year until 5 state courts issued what would be precedential decisions on the question of whether their state constitution protected a right to life, or at least touched on this in some substance. In January of last year, the South Carolina and Idaho Supreme Courts issued opinions on the same day. And then between March and June of the past year, 3 more state high court issued decisions in North Dakota, Oklahoma, and Indiana that touch on this issue. Now, to be clear, none of these decisions restored access in the states. I want to be clear about that. But the opinions do indicate that the issue at the center of this symposium, the pregnant person's right to life, is resonating not only with the public and in the media, but increasingly with the courts. So in particular, the 3 later decisions from North Dakota, Oklahoma, and Indiana recognize that at a minimum, their state constitutions protect abortion access when a pregnant person's life or health is at stake. So I'd like to quote briefly from each of those to hear what the court said on that. The Supreme Court of North Dakota held, quote, "There is a fundamental right for a woman to obtain an abortion in instances where it is necessary to preserve her health or life, rather her life or health, and we need go no further here to determine whether there are fundamental rights broader in scope." So in fact, leaving it open. Later that same month, the Oklahoma Supreme Court held that its constitution, quote, "creates an inherent right to life as well as liberty and stands as the basis for protecting a pregnant woman's right to terminate a pregnancy in order to preserve her life." And in June, the Indiana Supreme Court upheld a ban, but also under the state constitution's, quote, it's an inalienable rights provision or guarantee, held the state could not ban abortions when it is, quote, "necessary to protect a woman's life or to protect her from a serious health risk." Further, it stated it was not foreclosing future as-applied challenges under the state's firmly rooted fundamental right of self-protection, a right it described as one that might be, quote, "considered as an exercise of the right to life, an exercise of the right to liberty, a limitation of the scope of the police powers, or as a matter of equal treatment." So really resonating with the Pennsylvania court decision that came out so recently. So I want to pause to emphasize here again, all of these decisions were the result of early emergency litigation brought in 2022, right? Before, so these were by providers and clinics to immediately block abortion bans, even if temporarily. So none of those cases that I just quoted from were brought by patients experiencing dangerous pregnancy complications or had been denied abortion care. It wasn't until March 2023 that the center filed Zarowski versus Texas on behalf of individual women denied abortion care because of the Texas bans. That lawsuit started with a handful of plaintiffs, women denied care, and doctors who, under the threat of criminal charges, overwhelming fines, and professional penalties, were chilled from providing the medical and health care they knew was necessary to preserve their patients' life and health. So this case now has over 20 women as plaintiffs, and more have stepped forward to bring similar lawsuits that have since been filed in 3 other states, including some of the states I was just quoting from. These cases, however, are all in early stages of litigation, so there's no final court decisions. But it's fair to say the plaintiff stories in Texas did not go unnoticed by the other state courts. In a lengthy concurrence in Oklahoma, Supreme Court Justice Cogger, joined by 2 other justices, described how unworkable the medical exception was in real life. And she rhetorically asked, "Must a physician wait until their patient has a seizure, a stroke, experiences multiple organ failures, goes septic, or goes into a coma because of the fear of criminal prosecution? This certainly appears to be a problem in Texas." She not only references the Zarowski case, she goes on to describe in detail 3 of the Texas plaintiffs' pregnancy complications, including the severe threats not just posed to their life, but their health and their fertility. So that's interesting. That decision I quoted only says life, but when you read what the justices are citing and talking about, it goes far beyond pure physiological existence. So while concern for pregnant people's right to life was already at work in some of these early decisions, the courts did not have the benefit of a complete record of fully developed claims, facts, and legal arguments centering individual plaintiffs, such as those in the more recent litigation. So as these newer cases continue, and perhaps future cases addressing maternal health harms outside the abortion context, courts will increasingly have the opportunity and the obligation to consider the scope of a constitutional right to life for pregnant people in the United States. The legal theories that today's speakers are exploring and writing about are critical for informing those future decisions. Does the right to life encompass a right to health? Does it extend beyond medical care? How do the Reconstruction Amendments, including the prohibition on involuntary servitude, inform the right to life? How does the right to live a life of faith intersect with the right to define the meaning of life? And what lessons can be taken from international law and global move toward decriminalization of abortion? These are just some of the questions that today's panels will tackle, and it's my hope that today's dialogue inspires new thinking among scholars and advocates alike for theorizing the interdependent constitutional principles that inform the right to life for pregnant people, and more broadly, the human right to reproductive autonomy. So.
Okay. So we're running early, so we've got...
Great job, so good.
Yeah. So we've got 10 minutes for comments or discussion or other things that people would ask, or we can keep going. Yeah.
I love to talk both of you. Thank you so much for the work that you're both doing.
You want to introduce yourself?
My name's Rebecca Zippo.
Okay.
I was, Martha, when you were talking, I remembered an interview that I heard last summer. It was a member of the Oklahoma State Legislature who had voted for an absolute ban of non-reception for rape. And the reporter asked him, how could you justify that? And he said, well, the way I see it is when a person is pregnant, woman is pregnant because she's raped, she's not at fault, the fetus is not at fault. It's the rapist that's at fault, and he's the one that should be punished. Next question, what's the rape, conviction level? I don't even know if they asked that. But then she asked a question about providing welfare benefits and expanding the safety net. And you know what he said? He said that that's the father's responsibility. The father's responsibility.
Right. So I think you said a little bit about the connection between, I think Diana mentioned, I think, the connection between the lack of support in many, or maybe I read this somewhere else, but the lack of support in states that also are restricting abortion, that it really is not a holistic view at all of how we support people, but really, as you say, more focused on punishment.
Yeah. I mean, yes, you can, we have the information, there's lots of information. If you compare the states that ban abortion and look at their policies for a whole range of maternal health and family care support, here's the support for pregnancy and family care, and here's bans on restriction. And I think actually that, in international law, which I'm not an expert in, but the proportionality test there, it very much asks, is there another way to achieve it? If you claim to be interested in protecting potential life, do that in conjunction with the pregnant people that have to carry that life to term, but also look at all the other ways you can support it. If you're not doing that, this criminalization can't be necessary, it can't be proportional. And you don't see that balancing done in US courts, right? They say, well, that's policy decisions and the states don't have to do everything they could do. So I think that's a challenge, translating those arguments into the courtrooms. Cindy?
I'm Cindy, yeah.
Yeah, I'm going to talk about that a little bit, but also just want to raise up interesting cases where courts are recognizing protections, right, and really appreciated the discussion about how they're functional. And I feel like that's been the experience around the world. Most of the world has sort of developed.
Yeah, I did, again, not my area of expertise, but in the center litigates in other parts of the world, and right, we do this in Mexico and Colombia. Like, if you do look at the trajectory there, in some ways it feels very similar. The initial wins in the courts were for exceptions, and they were in very egregious cases, and we don't want to exceptionalize those. We don't want, right, the end goal is not only to have abortion access in those, but it does give me some hope when I see where those courts in those countries have gone in terms of decriminalizing abortion broadly. Lots of questions about how you translate that to the US context, I understand that, but it is at least possible in some legal regimes.
So I'm going to introduce Cindy, since you didn't. So Cynthia,
yeah.
that was Cynthia Suhu from CUNY Law School. Yeah, and you can introduce yourself too.
Sure, my name is Carol. So I'm fascinated by, and I'm assuming you're interpreting state constitutions and constitutions.
Yes.
So a couple questions is, are these surprisingly liberal courts in conservative states, or they're just
I should have said that, yes. These are in court, all the decisions I quoted were from courts that are in states obviously hostile to abortion, and those courts were not, it wasn't like the Kansas Supreme Court where we have had wonderful decisions before and would expect to, get a good, so some of that, and that's why I pointed out, a lot of those were the emergency litigation. Those weren't cases that were brought with a plan. We want to litigate in this state because we think the state's good. It was a necessity, and so those were surprising in some way, I think.
Or were they just going by the people? Were they following the Supreme Court and being kind of originalistic, or was the Supreme Court answer that question?
I think it varies. The Indiana decision is very originalistic. So I don't want to, I read the nice quotes. To be clear, those are not wonderful decisions writ large, and a lot of them do tend to follow a Dobbs-like history and tradition approach, which is another thing, kind of a whole nother topic, a whole nother symposium. How can we advance the right to life without buying into and reinforcing originalism? Because that certainly is not a long-term goal. Yeah.
So these health exceptions that they're not working. You have your own health exceptions that you're hoping that the courts will adopt. And so what is it?
Well, I don't want to get into there's other people in the room who I might let answer that, but look, as a practical matter, right, we are asking the courts to interpret those medical exceptions in a way that makes them workable, okay? So I'd say the simplest version is it's a good faith determination by the physicians, right? At the end of the day, that is the simplest, cleanest thing that could address a lot of the problems, at least in the limited kind of conditions that we're just describing about. These cases, as I said, are not going to open up abortion access for everyone, but there are doctors and patients who do not know what to do in these situations, and if it was clearly subjective good faith determination, people just trusted pregnant people and their health providers to make the decision, that would go far.
Yeah, and I'll just say on the good faith exception, putting together the amicus brief in Dobbs, where we looked at a lot of internationally and a lot of European countries, that was the standard. That it was there were criteria, there was regulation, but it was not difficult to get an abortion if you had a doctor's recommendation. Yeah.
Thank you. So yesterday I was reading about the Florida Supreme Court and this argument about right to life they seem to extend to fetal personhood. So I wondered if you could expand a little bit on that. And then my second question has to do with the Autonomy case that's on its way to the Supreme Court and how do you see that having an effect?
So, well, I was going to point to international, right, fetuses, unborn persons have never been recognized as a constitutional person in U.S. law or international human rights law. In fact, in human rights law, right, there's, the state can have an interest in protecting, advancing fetal life, but they are not right holders of their own. And the Florida argument you referenced was actually about the ballot initiative that's pending, and it was actually this kind of procedural, very normally par for the course part of the process where the Supreme Court of Florida has to approve the summary of the ballot. And of course, it's being challenged by Florida because they do not want voters to have the opportunity to make the Constitution clear on abortion rights in Florida. So interestingly, Florida did not actually advance that argument. There was one judge on the Florida Supreme Court who raised this. So it wasn't briefed, it wasn't really discussed going into it. But he was posing the question of, under our the language in the Florida Constitution is all natural persons, assuming that might include unborn, won't this constitutional amendment directly impact it? And doesn't that have to be disclosed to the voters? But that is not the case, right? There is no interpretation. There is nothing in even going to the, the research you did, like that was never the understanding of persons in the constitutions.
yeah.
So,
Another thought. But I guess this goes back to Maureen's charge to us at the outset, is that, of course, the state constitutions can be amended, and it's important to vote. Yeah, one more.
Jesse?
Jesse?
Yeah, hi, Jessie Hill from East Western Law School. So I just wanted to get thoughts from you on sort of the counterexample from some of these different cases, which is the Cox ruling out of the Texas Supreme Court, which I found just so surprising in that, like, not the result maybe so much as like the failure of the court to say anything like, we feel terrible, but this is a policy. Or to say, like, of course, if, in another case, we might rule differently, we don't want anybody to die.
I am.
Right? And I just, like, I don't know, like, what do you make of it? Is this where the court is going? Is this like, it's just I don't know. I just don't know.
Yeah, and I wish I had a quote with me of the district court judge's order requiring the state to allow her provider to provide abortion, because it was wonderful, and it was exactly on point about how egregious this was and how her life was on the line, and if the medical exception meant anything, she needed to be able to go. But yeah, I don't know what to say. It was a horrible decision, and so that is not a great sign for when the next case gets up to the Texas Supreme Court. But I guess going back to vote, and those are elected judges.
Right, and there are a lot of really surprising and terrible things happening in Texas, so.
Yeah, and I will say Molly Duane is here. She's litigating in Texas, so she wants to.
So I'm Kate's lawyer, so in my defense.
Yeah.
Claims
in that.
very narrow terror request, a constitutional issue will not act
Yes.
for the Texas court in her case, they are in the process. So we need to be some hope with that.
Yeah.
Better. But I also mind myself.
Yeah. Right.
That's partisan, but
Yes, it doesn't decide the issue at all, but in terms of your question of what to make of these judges, I don't think they're the judges that you want deciding your constitutional rights, maybe.
So I think I'm going to move to the next panel. I'll turn it over to Linda McLean.
directly to the next,
Yeah, thank you.
So the aim of the symposium, in addition to sparking a fruitful conversation, is to generate a useful and important written symposium as well. And so this panel will have two paper presentations by Cynthia Suhu and then by Rebecca Zitlow, and it will have commentators on each of the presentations. I'll introduce those people in a minute, but we'll also start setting the stage with a analysis by Professor Serena Maeri, who's the Arlen M. Adams Professor of Constitutional Law and Professor of History. And I'll just say one little thing about her, because there's full bios of everyone. Serena was one of the three co-authors of the Equal Protection Scholars Brief in Dobbs, which unfortunately was given a rather dismissive treatment, but we're going to give it a lot more attention here. And then after Serena sets the stage, we'll hear from Professor Cynthia, Serena's Penn Law School, sorry, shout out to Penn. After that, Professor Cynthia Suhu, who is the co-director of the Human Rights and Gender Justice Clinic at CUNY School of Law, will be presenting a paper about human rights, recognition of the right to life. And we will have two commentators on her paper. First, Erin Daly, who is a professor of law at Delaware Law School and the director of the Dignity Rights Clinic, the world's first legal clinic dedicated to advancing the dignity rights of people around the world. And then our second commentator will be Lynn Morgan, who is Mount Holyoke College Emeritus of Anthropology, medical anthropologist, and feminist science studies scholar who works mostly in Latin America and is currently writing about the backlash against reproductive rights movements in Costa Rica, Argentina, and Mexico. And then we'll move on to our second paper, which will be from my fellow Toledoan, Rebecca Zitlow, Distinguished University Professor, and Charles Fornoff Professor of Law and Values at University of Toledo, expert on Reconstruction, author of a couple different books on that topic. She teaches con law, fed courts, and constitutional litigation. And finally, joining us virtually, thank you very much, is Professor Brandon Hasbrook from Washington Lee School of Law, who has writes in the areas of criminal law, procedure, constitutional law theory, movement law, and abolition. And his work explores the legal and constitutional principles available to Congress and the courts to redress the way law fails Black and other marginalized people, and the structural possibilities for radical change in American society. So that's the format. I've asked the speakers to take about 8 minutes each, so we have room for colloquy and conversation. And the crucial question is, how are we doing with the slides? Okay, well, Cynthia, would you like to go first? Then we'll do Serena and Rebecca putting the U.S. constitutional law together.
Okay, great. Well, first of all,
Just one more minute. I'm going to be showing my panelists time signs, so just look my way.
okay, all right. Thank you so much for organizing this symposium, and I'm really thrilled to be here and thrilled to have commenters discuss my paper. I wanted to note that the paper I'm presenting builds on a talk that I gave at Case Western and also with the Gender Equity Institute. And also shout out to the Center for Reproductive Rights for translating the Colombian constitutional case. So, recent cases from Colombia and Mexico striking down criminal abortion laws have gotten a good deal of press, touting how these courts are going in the opposite direction of the U.S. Supreme Court. I was curious about how they got there, especially because in Colombia and Mexico, unlike the United States, there's actually a constitutional obligation to protect prenatal life. So there's a lot to these cases, but my main focus is on evolving human rights standards that are reflected in these cases, rejecting the use of criminal law. That is, these cases not only recognize the human rights violations inherent in any abortion ban, but also recognize the unique harm caused by criminalization. The analysis considers the real-world impact of criminal abortion laws, specifically that they don't actually prevent abortions, and but they prevent people from accessing healthcare services and information, making care more difficult to obtain and potentially dangerous. They also widen the net of carceral systems, imposing a different kind of harm. And they have a disproportionate impact on communities already made vulnerable because of discrimination, lack of resources, over-surveillance, and other factors. So rather than resort to criminalization, the cases and human rights standards emphasize policy alternatives that support individual choices about reproduction, including support for sex ed, contraceptives, prenatal care, abortion care, and childbirth. They also encourage programs providing resources and support so that individuals feel comfortable becoming parents. I'm going to provide some background on the cases and then discuss what they specifically said about criminalization. So in the recent cases, the Colombian Constitutional Court and the Mexican Supreme Court struck down laws criminalizing abortion. There's a long history of criminal abortion restrictions in both countries, but in the last 15 to 20 years, the courts have held that abortion can't be criminalized when it results in extreme human rights violations. So specifically, they found that abortion cannot be a crime in cases of rape, when pregnancy endangers the pregnant person's life or health, or when the fetus has serious malformations incompatible with life. These are sort of the exceptions that Diana was talking about earlier. But the recent cases go much further and recognize that people must have the right to choose an abortion whether or not continuing the pregnancy imposes exceptional harm. The court's reasoning is impacted by their past experiences with the criminal law and the unworkability of the exceptions. The cases recognize that prohibiting abortion violates multiple human rights, and I'm not actually going to go into all the rights because I only have 8 minutes, but they also, but they're highly influenced by human rights law, which is part of the constitutional block or bundle of individual rights that's actually protected in those countries. So unlike the United States, both countries recognize an affirmative constitutional duty to protect prenatal life. But as the earlier panel discussed, consistent with international and regional human rights law, they found that prenatal life is not a rights holder, i.e. there's no fetal personhood, and that the obligation to protect prenatal life is not absolute and increases with gestational stage, which sounds familiar. The courts adopt a balancing approach to reconcile the constitutional rights and interests. They find that banning abortion is an unacceptable absolutist position because it completely nullifies the right to decide and ignores the dignity and autonomy of pregnant people. So the Mexican court strikes down the criminal provision, and the Colombia court holds that abortion cannot be criminalized before 24 weeks, and that abortion is not a crime when the exceptional circumstances apply regardless of gestational stage. Key to both decisions is a finding that there are other means for the state to protect prenatal life besides criminal law that does not violate the rights of pregnant people. I mentioned that the cases heavily relied on human rights law and standards, and a lot of the human rights analysis really dovetails in what the Colombian and Mexican courts said. So I'm not going to discuss the human rights standards in depth, but I'll just note, like Martha said earlier, human rights bodies and the World Health Organization have taken the position that states should never criminalize abortion. And it's actually in the comment. Martha didn't quite get to it, but it forces people, so the state should never criminalize abortion because it forces people to resort to unsafe abortion, violating the state's obligation to protect, respect, and ensure individuals' rights to life and health. So the Colombian court's rejection of the criminal abortion law relies on a series of cases that it developed on the rights of incarcerated people dating back to 2013. The cases apply the criminal law principle of ultimo ratio, which the Mexican Supreme Court relies on as well. And there are three basic parts to the principle. First, criminal law should only be used to prevent conduct that inflicts substantial harm to others or to achieve a legitimate state interest. It cannot be used for symbolic or strictly punitive purposes. Second, because of the dignitary harms and the restrictions on freedom imposed whenever criminal law is used, even when legislatures have a legitimate interest, there are substantive limits to when the courts can use criminal penalties. The criminal provisions must be suitable, necessary, effective, and proportional to the state interest. This inquiry includes consideration of the harm caused by the criminal penalties, as well as whether or not it's discriminatory or infringes on other constitutional rights and interests. Third, criminal law can only be used as a last resort when it is not possible to use less restrictive means. Legislators must assess the impact of criminal sanctions and actively consider less restrictive alternatives before adopting criminal laws. Accepting that criminal abortion laws were adopted to further the legitimate purpose in protecting fetal life, the courts found that the laws violated the last resort principle and other substantive requirements. Specifically, they found that the criminal laws were not effective given the country's own experience and global data showing that criminal abortion laws do not decrease abortions. Second, the criminal laws cause real harm. Not only do they violate the rights of pregnant people, they endanger their lives by increasing the risk of unsafe abortion outside of the medical system. Third, the criminal laws had disproportionate and discriminatory impact on marginalized communities that already face discrimination and lack of resources. The courts explained that these communities had the least access to sex ed and contraceptives and faced the most difficulties traveling to jurisdictions where abortion is legal, and they were disproportionately prosecuted and suffered negative health consequences. Finally, the courts noted that discrimination and dignitary harms embedded in a law that criminalizes behavior associated with sex-based characteristics and treats pregnant people as instruments of reproduction by using criminal law to compel highly personal decisions. Both courts found that the legislatures impermissibly adopted criminal laws as a first resort, and they talked about alternatives. The courts rejected the assumption that protecting prenatal life is inherently at odds with respecting and protecting the rights of women and birthing people. Rather than looking at the decision to terminate a pregnancy in isolation, they adopted a broader time frame. Thus, alternatives to protect prenatal life included policies to help prevent pregnancies, make informed choices about termination, and support people who have children. The courts emphasized the state's obligation to ensure that all people have access to sexual and reproductive health information and services, including removing barriers to services and ensuring provision of services in public health facilities. They also described programs to alleviate conditions that may prevent people from continuing wanted pregnancies, including lack of resources, child care, and labor and educational protections and opportunities. So just a little bit on the United States. At my last count, 16 states have laws criminalizing abortion at all stages, and 4 have passed criminal provisions that apply after 6 weeks. Our experience with criminal law is not dissimilar to Mexico and Colombia. Criminal laws have not prevented abortions. Instead, there's just been a shift of where abortions are performed. Recent studies have showed that abortions have actually increased in 2023 compared to 2020. Criminal abortion bans have caused real harm, and we've already discussed the denial of crucial care because doctors and hospitals are afraid of being criminalized. Criminal bans disproportionately impact Black and Indigenous communities and people who are unable to travel. And on last resort, I'm still crunching the numbers, but reports and data indicate, not surprisingly, that states with criminal abortion bans are the least likely to have supportive policies for mothers and children. These include family leave policies, et cetera. So in closing, I'll just say, of course, Mexico and Colombia are different than the United States, but I'm hoping that the reasoning can help inform legislative and policy discussions, and many of the concerns about meaningful access to sexual and reproductive health services, harms of criminalization, and the disproportionate impact on communities of color echo concerns of the reproductive justice movement. I think we can also think about how we can build bridges to other social justice movements who are trying to deal with over-criminalization, and that the court's balancing approach might create an opening to engage with people who traditionally have opposed abortion. Look forward to your comments.
Thank you. Okay, so we'll now have two commentators, Erin Daly and Lynn Morgan. Erin, do you want to go first? Okay.
Thank you. I assume this is on. Hi. Thank you very much to the organizers, and thanks to the audience. There's so much knowledge in this room and experience in this room on these issues. It's just such an honor to be here. So thank you very much, and thanks for giving me the opportunity to comment on Professor Suhu's paper. What a tour de force that is. I mean, I think you've just done so much in so little time, and just raised so many really interesting and important issues. So what I would like to do is just comment, obviously, on just a very few of them, and then I'll make a couple of suggestions about different ways of looking at some of these issues. I especially want to commend Professor Suhu on just the initial decision to look abroad. And to see what's going on in the rest of the world. Martha sort of invited us to do this in her initial comments, and I'm really sort of excited to see this growing scholarship of looking abroad, not only because, sorry to say, but I feel like we're sort of desperate for new solutions, right? And so it makes sense to look abroad. And it also, we can learn so much, we can learn about different ways of reframing the problem, and we can also learn about different solutions that other countries are coming to and their reasoning, as you talked about, but also the language they use in their cases will help us, I think, if we really pay attention to it, really sort of think hard about the choices that we make about language, which isn't just about rhetoric, but also about framing and what we take for granted and what we don't. So I'll comment just a little bit on some of the themes that Professor Suhu mentioned. She mentions in the paper sort of some of the general aspects, the things that you can draw out of these papers. The incremental constitutional obligation to protect prenatal life, the rights of pregnant people, the issue about balancing the rights of the fetal interest versus the woman, and then sort of underlying all of this is the rejection of criminal law and a questioning about sort of what do we do with international and just basic human rights obligations, and how do those sort of figure into our thinking. And implied in these ideas, I think, are several foundational assumptions or presumptions, even just about the constitutional project itself, as applied in this context. But this context isn't just about this context, right? It's about, as your question suggested, and as other people have already been saying, it's about how we think about constitutionalism in this country in general, and what I'll just call the problem of reproductive rights as at this moment is just one aspect of that. So, and I think that when we look abroad, we don't just see different kinds of decisions and different kinds of solutions. What we see is different understandings of what the constitutional project is all about. And these are really, really deep issues, right? It's not just about constitutional interpretation and originalism versus something else. It's also about what is the purpose of a constitution? Is it a document that is meant to be, as Professor Suhu has elsewhere written, transformative? Is it about is it a document that's intended to be progressive or evolutionary? In Canada, they talk about constitutionalism or constitutional interpretation as a living tree. Like, it has to grow, right? It has to continue. We shouldn't be bound in the 21st century by what, I won't even characterize them, but by what some people thought in the 18th century. You can just fill in your own adjectives about the brilliant people who created our Constitution, but their relevance to our day-to-day life here is, I think, something we can wonder about. And tied up in that is sort of the question about the obligation of the Constitution and its interpreters to be just realist, for lack of a better word. How important is it for judges who are interpreting either federal or state constitutions to pay attention to what's actually going on? And of course, this has particular relevance when we're talking about issues that affect women in general, but also certainly about reproduction, where the reality of how people are living and how people are experiencing these judgments from above is just so different, right? There's just a big chasm there. So one of the ways of thinking about this whole issue really is sort of one of the things you said was that abortions will happen, right? This isn't about whether we have abortion in America or not. It's about whether they happen safely or not and what the role is of the law and the Constitution and the judges who interpret and apply our constitutions, federal and state, to address those realities on the ground. Even deeper than that, questions about constitutionalism raise questions about the social state, right? Something that doesn't really exist in American sort of constitutional thinking, but exists in much of the rest of the world, right? The whole purpose of the state in much of the rest of the world is frankly just to help people live better lives, right? That is why we get together in states. Okay. I'll go even faster now. She also, looking at the cases that she's talking about, also raises questions not only about intersectionality of identity and how we understand the people who are sort of the subject of these laws, but also notions of the indivisibility of rights, another issue that is sort of another way of thinking that we get from international human rights law, the recognition that rights are not in silos the way we tend to think of them. Is this an equal protection issue or a due process issue or a First Amendment issue? But in reality, rights are indivisible, they're interdependent, they're interconnected, and you can, in less than a second of thinking about the abortion issue, you see all these, different rights that are implicated, rights about economic rights, rights about housing, rights about access to transportation. I mean, all kinds of different things, education, and yes, I'll say it again in case some of you forgot that it has already been said, the right to vote, relevant also. And it raises issues about our criminal law as well. Many countries reject, and you touched on this also, and I think that there's just so much there, but many countries reject the idea that the criminal law is about retribution. Imagine that. The criminal law is actually meant to do other things in other countries. It's not meant to punish people for decisions that they made. It's not even meant to deter other people, which is a truly sort of dignity-denying practice. It's meant for the purpose of rehabilitation. It's meant for the purpose of helping people go from a bad situation that they find themselves in to a better one, right? To be able to make better decisions in their lives. And I'm not, believe me, I'm not assuming that these are criminal law issues for the reasons that Professor Suhu was suggested, but even if we accept that these are criminal law issues, the criminal law has to be rethought, right? Because it shouldn't be about punishing people for making decisions about their lives. The last thing I'll just want to mention is really picking up on human rights approaches and picking up on sort of the invitation that Martha Davis suggested about thinking about the right to life, and of course the whole theme of this, thinking about the right to life, and you mentioned it as a matter of international human rights law, but in much of the world, the right to life is the right to live with dignity, right? So it embodies within it a whole sort of substantive panoply of rights that are part of what it means to live with dignity. After Dobbs, 1 year after Dobbs and about 14 months after Dobbs, the Supreme Court in India and then again the Supreme Court in Mexico issued these amazing decisions, and you have to imagine that those judges had read Dobbs and said, we're not going there, we're going here. These really strongly dignity-affirming decisions about the importance of allowing all human beings to make important decisions for themselves. Basically, it comes down to that. There's a lot more there, but I'll mention that.
Thank you.
Thank you very much.
Terrific. And you're right next to me, so these time things are going to be easy.
Hello, is this on? Yeah. So the obligatory but no less heartfelt thanks to the organizers for inviting me, especially as a medical anthropologist, somebody who does not have legal training. So I just want to preface this by saying that my reading of your paper was as someone who has been studying the backlash against sexual and reproductive rights movements from the perspective of Latin America, several different countries and constituencies, and trying to take seriously the perspectives of people with whom I disagree, as people who also are people of integrity and people who hold their beliefs very dearly. So that's a big ask, but it's what I strive for. So my current research is focusing on the rise of the global anti-abortion coalition and how this alliance influences reproductive governance, especially in Latin America. And of course, there's a very real and ongoing relationship between what's going on in different Latin American countries and contexts and what's happening in the United States. Now, as you all know, in several countries have recently legalized or decriminalized abortion in Latin America, in addition to the cases that you're talking about, Argentina in 2020 and Uruguay in 2012. So this paper, which I really enjoyed reading because, as you said, it's a tour de force that brings together the arguments against criminalization in a very succinct and forceful way. I think it's very helpful. Professor Suhu analyzes the Colombian and Mexican high court decisions, showing how they make the case that criminal law should not and need not be used to regulate abortion or to protect the state's interest in prenatal life. So you're directing your argument to a US audience primarily, which makes sense given that in the United States we're seeing an escalation in efforts to charge people with crimes related to their pregnancies. Just last week, you may know that the Democratic Women's Caucus sent a letter to the Biden administration urging that it protect pregnant people from criminal prosecution. If the US courts were to adopt anti-criminalization arguments, as the Colombian and Mexican high courts did, it could stop what the Democratic women called the long-standing pattern of criminalization of people on the basis of their pregnancies or pregnancy outcomes, unquote. So to echo what Erin said, I would like to applaud Professor Suhu for focusing on what's happening in Latin America and realizing that we can learn from what's going on in Latin America. That is a lesson that I don't see as often as I would like to in the arguments that are made in the US. I think there are legal lessons to be drawn, I agree, from Colombia and Mexico, and it's vital that we pay attention to the interplay between what's happening in the United States and what's happening elsewhere in the world. So much of our conversation is focused on the US for obvious reasons, but we shouldn't forget that US-based anti-abortion advocates are also committed to abolishing abortion in other countries as well. And those efforts are continuing even in the or under the rubric of the Biden administration. So a couple of questions about the paper. One, just very briefly, a minor issue. I wonder about the logic of resorting to the language of decriminalization rather than legalization. This was something that I know has a history. I know there are historical and strategic reasons why Latin American abortion rights strategists decided to take this route, but I'm not sure what that history is, actually. And so I wondered if you could talk just very briefly about why the language of decriminalizing rather than the language of legalizing abortion. Okay, the second point, and something that I think is more substantive, as you well know and as you articulate in the longer paper that I read, the Colombian and Mexican high court decisions both rest very heavily on rulings issued by the Inter-American human rights system. There's a reason for that, which is that decisions by the Inter-American Court of Human Rights are considered binding on the 20 countries of the Americas that have ratified the American Convention on Human Rights. The US never did that. The US never ratified the American Convention. And so the US courts and politicians regularly reject its jurisdiction and ignore its decisions. Given the US Supreme Court's antipathy towards international human rights treaties and courts, I wonder about crafting an argument that rests on a body of law that the justices will reject out of hand, and indeed did reject out of hand. The majority of the current U.S. Supreme Court justices showed themselves to be doggedly uninterested in international human rights. Dobbs never mentions the words human rights, and it does not reference the International Human Rights Court's abortion rulings, except in the dissent. Isn't it reasonable, then, to expect U.S. courts to consider anti-criminalization arguments given their disdain for international human rights? It's a larger question that really underlies a lot of the premise of this whole conference. Like, how do we advance a human rights perspective if our courts don't care about human rights? So I'm aware that in June 2023, the Inter-American Commission on Human Rights urged the U.S. to protect and guarantee reproductive rights. But are there ways to convince U.S. courts to respect or make better use of the inter-American human rights system? Okay, third point. Let's be clear that there's an ongoing effort to outlaw abortion internationally, of which Dobbs is just one piece. So bearing this in mind, the argument against criminalization needs to be understood not just on its own merits, but in relation to a proliferation of legal arguments that are being mustered by scholars both for and against abortion rights internationally. So how does this argument, the anti-criminalization argument, stack up against others? And how do we know? The closer we get to a human rights consensus that states should never criminalize abortion, the more intense the backlash from anti-abortion activists and legal scholars. How, I wonder, would Professor Suhu respond to conservative counterarguments, such as the argument that the Colombian and Mexican opinions are too reliant on what CFAM has called soft law emanating from UN agencies, and that soft law is undemocratic and not representative of citizens' views? What about the argument that sovereign nation states need not be bound by the jurisdiction of the inter-American human rights system? What about the conservative argument that certain rights, including the right to life, are unalienable? That is, you see that in the Geneva Consensus Declaration, in Pompeo's Commission on Unalienable Rights, and certain other documents that will rise up again if the Republicans come back into office. How do we respond if and when the Republicans cut funding to UN agencies, including the WHO? Do you remember in the middle of the pandemic when Trump threatened to cut off funding to the WHO? That was in no small part an anti-abortion move, something that wasn't really realized or recognized by the press to the extent that it should have been. And the cutting funding to these organizations is outlined in the Project 2020 that the Heritage Foundation is spearheading right now on the presidential transition and the blueprint to the next, what they hope will be Republican administration. So just to finalize here, I really enjoyed reading this paper. I like it very much. I'm concerned about the larger picture in the context of political and strategic feasibility given the disdain for international human rights that we see on the part of U.S. courts. Thanks.
Thank you. Okay, so now that concludes our first paper discussion. Serena Maieri is now going to talk about her historical research and the relevance of today's discussion. I believe we finally maybe have her slides ready to go. Okay. All right, great.
Thank you so much, and thanks so much to the organizers and also to the wonderful folks who helped me scramble to get this together. I really appreciate it. So reading Dobbs, I think it's tempting to jettison any methodology that looks to the past as a source of rights or as relevant constitutional principles today. Justice Alito's opinion employs a very narrow version of history and tradition that tethers 21st century constitutional rights to the cramped imagination of white male property elites who excluded most Americans from the polity. But I want to argue that Dobbs shouldn't lead us to reject history's relevance to constitutional law or to political debates about reproductive rights and justice. So I want to submit to you that the question is not whether, but how we talk about history and its role in constitutional interpretation and politics. So I probably don't need to convince anyone in this room of the flaws of Dobbs' treatments of history. I wanted to just talk about, distinguish between a few different kinds of problems. One, of course, is Dobbs' flawed factual account of the past. Justice Alito invokes authorities such as Bracton, Hale, and Blackstone to support his assertion of an unbroken tradition of criminal punishment for abortion from the earliest days of the common law. Well, we know that leading professional historians tell a very different story. Pre-quickening abortion was widely practiced in the colonial period and early republic, and information about ending a pregnancy was widely available. The 19th century physicians' campaign to ban abortion was part of a professionalization effort, and combined concern for fetal life with nativist, racist, paternalist, and misogynist sentiments that are contrary to our current constitutional assumptions. So that's the first problem. A second problem, of course, is the method of constitutional interpretation that Dobbs uses. Looking to how many states banned abortion in 1868, of course, elevates the preferences of men who enslaved people of African descent and limited all women's legal, political, and personal freedoms and prerogatives. And I could go on about that, but I won't. As Reva Siegel has shown, the state counting method is not a neutral method, as Justice Alito claims. It originated in segregationist defense of Plessy, was rejected in Brown, resurfaced in cases like Bowers, and we thought has long since been rejected by the Supreme Court in cases like Lawrence and Obergefell and U.S. versus Virginia. Bizarrely, Dobbs does not even briefly probe the ideas and intentions of lawmakers who fought for the Reconstruction Amendment's enactment, right? Much less the disenfranchised of that time. There are many other problems, too many to list. The selectivity, inconsistency, and hypocrisy with which the Roberts Court invokes history across other contexts, as scholars such as Melissa Murray and Kiara Bridges have analyzed. And last but not least, I'll just mention that the majority casually disregards a half century of constitutional sex equality jurisprudence when it rejects equal protection arguments for abortion rights, albeit in dicta, I want to emphasize. Okay. So what I want to argue, though, is that history does have a critical role to play after Dobbs, critical kind of in both senses of the word. We need look no further than the work of Peggy Cooper Davis, who calls on us to recapture an anti-slavery history and tradition based on the lives and thought of enslaved and freed people whose reproductive oppression and resistance motivated the Reconstruction Amendments. To Michelle Goodwin, who shows how the framers saw violent reproductive exploitation and family separation as central to what these amendments were trying to overcome. To Dorothy Roberts, who urges us to emphasize the striking connections between abortion bans and the exploitation of enslaved women's reproductive labor, and between forms of reproductive injustice that recur across time. So critical approaches to history ask very different questions of the past than Justice Alito asks of the past. They use the past as negative precedent, identifying injustices to be overcome, and also as positive precedent to use histories of resistance and creative constitutional advocacy as models, potentially, for the constitutional principles of the present. History can help us locate abortion bans in a long history of reproductive control and anti-democratic practices. And that's why I just want to kind of run through some of the ways that, that history can help us in that regard. So history can help us frame abortion restrictions as part of a longer history of reproductive control, as Judge Carlton Reeves invited plaintiffs to do in the Dobbs litigation. There, plaintiffs situate abortion bans in a history of forced pregnancy and childbirth, eugenic sterilization, child removal, especially as it affected Native and Black families, selective state support for certain kinds of mothers and not others, and certain kinds of families and not others. History can help us, History can help us link past and present injustices. To see, for example, the Brittany Watts case as part of a long history of criminalization of Black motherhood, to see abortion travel bans as resembling Fugitive Slave Act, to see the Comstock Act as reminiscent of, well, the Comstock Act. It can also help us to expand the frame in the ways that we've already discussed, to ask what states would do if they truly wanted to protect maternal health and the lives of children and families. It can debunk abortion as eugenics claims, as Melissa Murray has systematically done. It can expose the links between reproductive control and anti-democratic political traditions, to expose to public view how the right has long used abortion as a political weapon to accomplish a much more expansive agenda by capturing the federal judiciary and defying public opinion across a wide range of areas, as Mary Ziegler and others have chronicled. It can highlight how abortion control, reproductive control generally is a tool for authoritarian movements, past and present. I could go on and on, but I'm going to skip over some of this for reasons of time. And talk a little bit about how and talk a little bit just about how history has provided resources already to advance reproductive rights in the state. Okay. So advocates have used historical evidence to argue for expansive approaches to in the interpretation of state constitutions. The Kansas case is a great example of that, a case that happened before Dobbs. They've argued that state exceptionalism incorporates populist and progressive traditions and early support of women's suffrage in some of these Western states. We saw just last week the Pennsylvania Supreme Court issuing a rather remarkable decision. Remarkable because it accepts arguments that scholars and advocates have been making for decades, notably. History also, and I'll wrap this up, discredits both old and new abortion restrictions. In religious freedom cases, historical context has allowed plaintiffs to argue, among other things, that many religious traditions have a very different view of the morality and sometimes necessity of abortion, especially but not only when pregnant people's life or health is at risk. And finally, I just want to talk briefly about the role of historical evidence in cases where what's at stake is not necessarily a fundamental right to abortion, but just the right not to risk death or serious health consequences from a dangerous pregnancy. And so in some of the cases that Diana Kazdan mentioned earlier, plaintiffs had argued, advocates have argued that even in the darkest days of women's subordination, abortion law has contained life-preserving exceptions, right? Physicians have retained discretion to perform abortion when women's health was at risk, not just lives. And as has already been discussed, courts in red states have accepted these arguments. And I just wanted to say one last thing, mentioning Justice Yvonne Cogger's concurrence for the Oklahoma Supreme Court decision. And that is that she uses history simultaneously to expose the absurdity of using archaic past practice as the measure of contemporary freedoms, and to highlight the extremism of abortion bans that fail even to provide women and other pregnant persons with the minimal protections afforded by these antediluvian lawmakers.
Thank you. Rebecca. Okay, I want to thank Brandon for his patience. Okay, so now, Rebecca, we're well teed up for your talk about 13th Amendment, and then Brandon will be commenting, so let's get started. Thanks.
Yes. Thanks so much for inviting me. It's really great to be here, and I just want to say that I speak not just as a scholar, but also, now the microphone's working, okay. But also as a member or former member of the Planned Parenthood of Northern New England Board, and an ongoing member of the Planned Parenthood of Vermont Action Fund, which spearheaded the fight for the Reproductive Liberty Amendment. I'm looking forward to talking more about state constitutions later. At the oral argument for Dobbs, Justice Amy Coney Barrett commented that safe haven laws allowing women to put their babies up for adoption would solve the problem of women being forced to bring unwanted pregnancies to term if they no longer had a right to choose an abortion. Justice Barrett's comment, which was echoed by Justice Samuel Alito in his majority opinion in Dobbs, reflects a callous disregard of the experience of women of color throughout our nation's history, beginning with a tragic cruelty of chattel slavery. Women of color have not only been forced to give birth, but also to give up their children after they were born, historically to the enslaver, more recently disproportionately to child protective services, as Dorothy Roberts has written about. People of color have also disproportionately been denied the ability to have children, subject to forced sterilization and coercive birth control regimes. Overcoming this history requires more than an individual autonomy right to choose an abortion that was recognized in Roe but rejected in Dobbs. It requires a holistic campaign for reproductive justice, the human right to maintain personal bodily autonomy, have children, not have children, and parent the children they have in sustainable communities. I'm arguing today that the 13th Amendment provides an effective tool and framework for reproductive justice. The amendment provides that neither slavery nor involuntary servitude shall exist, and is a source of positive rights that are enforceable against state and private actors. It not only abolished slavery, but guaranteed fundamental human rights to formerly enslaved people and all people, with its promise for racial and economic justice and its protection against coercive practices. A number of scholars, including Michelle Goodwin, who will be speaking later today, have already argued that the denial of abortion rights violates the 13th Amendment. Agreeing with those scholars, I'm laying out a blueprint for 13th Amendment-based advocacy for reproductive justice, based on 2 lines of 13th Amendment doctrine. First, the denial of reproductive liberty is a badge or incident of slavery remediable under the 13th Amendment. Second, forcing people to give birth or forcibly denying people the right to give birth and parent one's wanted children imposes an involuntary servitude which violates the 13th Amendment. Section 2 of the 13th Amendment gives Congress the power to remedy what it rationally believes is a badge or incident of slavery. Some scholars have argued that courts also have the power to directly remedy badges or incidents. According to William Carter, a legal injury is a badge or incident of slavery when it is proximately traceable to the system of slavery, taking into account the relationship between the group affected and the centrality of the practice to chattel slavery in this country. The denial of reproductive autonomy was a central feature of our country's system of chattel slavery, arguably the cruelest feature and clearly a badge or incident of slavery. Enslaved women were raped or forced to breed with other enslaved people. Under the laws of slave states, children of enslaved women had the legal status of their mothers, a tacit recognition that they were often the product of enslaver rape. These children were often ripped from their parents' arms and sold away from them, never to be seen again, a practice which was an important part of the profitability of slavery, especially in the mid-Atlantic states. As Sojourner Truth memorably declared, "I have borne 13 children and seen most all sold off to slavery." The most common motive cited for fleeing by fugitives from slavery was the threat or sale of oneself or one's family members. And during the antebellum era, other anti-slavery activists often decried these practices, a critique central to their anti-slavery message. For example, an 1860 New York Times editorial argued that slavery treated a black person as a chattel breeds from him with as little regard for marriage ties as if he were an animal. During congressional debates over the 13th Amendment, the amendment supporters often spoke of the enslaved people's lack of reproductive freedom as one of the denials of human rights which would be remedied by the 13th Amendment. Thus, the evidence that the denial of reproductive liberty was a badge or incident of slavery is overwhelming. This argument is strongest when addressing the denial of reproductive liberty to the descendants of formerly enslaved people and other people of color. But under Carter's nexus, the denial of reproductive autonomy is so central to slavery that it might be considered a badge or incident when denied to any person. Kimberly Crooms Robinson has argued correctly, I believe, that the 13th Amendment provides a source of congressional power to enact a federal law recognizing a right to an abortion. And the only question, in my mind, is whether courts could strike down restrictions on reproductive liberty without congressional enforcement. The second argument is based on the involuntary servitude clause. 13th Amendment prohibits not just slavery, but also involuntary servitude. Arguably, laws forcing people to give birth impose an unconstitutional involuntary servitude on pregnant people, directly violating the 13th Amendment. The involuntary servitude clause calls on courts to identify and enforce unenumerated rights. And in the slaughterhouse cases, the court recognized that the word servitude is of a larger meaning than slavery. In Bailey versus Alabama, the court defined involuntary servitude as freedom of compulsion of one individual to serve another. And in Pollock versus Williams, the court held that a law which enabled a harsh overlordship imposed an involuntary servitude. Andrew Koppelman has argued for years that laws compelling pregnant people to give birth impose an involuntary servitude on them. Of course, the injury of enforced motherhood inflicted on a person of an entirely different scope and magnitude than lifetime servitude inflicted on enslaved people, since it is temporary, involves less than total control over the body. However, it is arguably the same kind of injury because it compels pregnant people to serve the fetus, imposing an involuntary servitude on their bodies. The law of involuntary servitude is relatively underdeveloped, and until now is focused almost exclusively on conditions of employment. However, as Pamela Bridgewater argued, being impregnated and bearing children was a significant part of the work performed by enslaved women. Moreover, as the court recognized in Casey, the denial of reproductive liberty restricts economic opportunities for people who are forced to give birth. Most importantly, a strategy based on the involuntary servitude clause acknowledges the fact that laws have historically repeatedly been used to coerce people into bearing and raising children and depriving them of the right to do so. The reproductive justice movement has long recognized the centrality of coercion in their fight for reproductive freedom. The involuntary servitude clause is an important constitutional vehicle for making these claims. What would it look like if slavery and involuntary servitude really was abolished in this country? What if our laws really did engage in remedying the badges or incidents of slavery? Doing so would further the cause of reproductive justice. And I'm really excited to hear what my pal Brandon has to say about my paper. Thank you.
Okay. So, Brandon, could you just plan to speak for 8 minutes?
Yeah, that's a goal. I got my time.
Thank you. Okay.
So I want to
Last but not least.
Yeah, I want to thank Boston University and the symposium organizers for inviting me to participate in this timely and necessary discussion. I want to thank my fellow panelists for sharing their brilliance. I'm incredibly fortunate to be in your company. Finally, shout out to all the students in the room. You all are going to be on the front lines working in solidarity with our most vulnerable communities, building a future breathed in love, equality, and justice. It is a privilege to comment on Professor. I know there's a little delay here. It is a privilege to comment on Professor Zitlow's compelling essay. Some real talk. First of all, I'm always glad to see more work examining the badges and incidents of slavery. This essay is absolutely right to focus on how forced reproduction and a critical process to the propagation of slavery. Once the international slave trade was abolished with the complicity of enslavers interested in increasing the market value of their slaves, forcing enslaved women to bear children was the only way to get new slaves. Whole plantations in states like Virginia made the bulk of their profit in the domestic slave trade. Forced reproduction's critical role in chattel slavery clearly marks it as one of the badges and incidents of slavery. But the badges and incidents of slavery are more than just the cogs in the machine of old school chattel slavery. The badges and incidents of slavery also encompass conditions and institutions that would encourage the reemergence of some form of slavery. The Reconstruction Congress wanted to ensure that abolition didn't fail because of the emergence of slavery 2.0. They wanted to prevent the creation of a permanent underclass vulnerable to new systems of exploitation. Modern restrictions on reproductive autonomy have the potential to do just that. People have to miss work to deal with pregnancy, childbirth, and childcare, facing career disadvantages. The resulting economic situation leaves the children at structural disadvantage in education, career opportunities, and encounters with our carceral system. People at such disadvantages are more vulnerable to economic exploitation throughout their lives. Creating a mass of such people would be a boon to moneyed interests looking to develop a new sources of free and cheap labor. And when you look at the whole spectrum of attacks on reproductive autonomy, that sure looks like part of the program. They're not stopping at abortion. They're going after birth control, sex education, the works. But there's also a direct approach. The 13th Amendment didn't prohibit slavery by name, but by describing within a broader category in the involuntary servitude clause. Unlike most rights in the Constitution, the involuntary servitude clause reached directly to private action and created rights to protect people against it along with the laws supporting it. No person can be required to serve another against their will, regardless of who those people are, and regardless of who is responsible for trying to subvert that person's will. I agree with this essay's framing of legally requiring a person to continue a pregnancy against their will is involuntary servitude. It's co-opting that person's body and their labor, in both the literal and figurative sense of labor, to serve the fetus and the political forces that want to ascribe that fetus personhood. And that's all before the labor involved in child rearing. That's within the scope of the 13th Amendment's text, directly addresses. It's good to see the argument laid out that abortion bans and related attacks on reproductive autonomy conflict with both of the ways the 13th Amendment is supposed to protect against slavery. My central critique of this essay is the democratic optimism. Its constitutional arguments were largely developed in an era when our legislative and judicial branches were functioning institutions of a democracy. These days, both have shown dysfunctional and anti-democratic traits, and until that democracy deficit is corrected, there's not much room for optimism in either institution adopting creative, rights-affirming interpretations of the Constitution. The 13th Amendment's potential for protecting reproductive rights is likely a non-starter for now. But state constitutional provisions that prohibit slavery could potentially be used to counteract state abortion bans. Some examples: Nebraska, quote, "There shall be neither slavery nor involuntary servitude in the state." Some states also explicitly protect reproductive freedom in their constitutions, such as California, Vermont, Ohio, and Michigan. Other states, including Maryland and New York, have forthcoming votes on similar provisions. Realizing the promise of the Constitution to protect reproductive freedom will require reigniting the political will for Reconstruction, either at the state or federal level. There's another flaw implicit in that line of criticism. It's not clear exactly what the essay is adding to the conversation, but I think its potential is truly profound. Allow me to explain. All of these arguments have sound support, but they're not new. And unfortunately, the political and legal environment is going to make them hard to advance either through jurisprudence or legislation. Now, there's value in imagining new outer boundaries in legal theory, and there's value in providing additional support for those theories. But that's not what I see happening here. So we need to think about where this could go as the piece fleshes out. There's potential here to have a frank discussion about the challenges to advancing these theories in both the political and judicial realms. Those challenges are real. Congress isn't a functioning legislative body right now. Even before the current term, the Senate has been an anti-democratic stumbling block for years. Even if we manage to get a legislative willing to act on Reconstruction support for modern reproductive freedom, we'd face a right-wing reactionary judiciary packed with relatively young judges. And those judges, especially the ones on the Supreme Court, aren't going to buy novel 13th Amendment arguments and enforce the original meaning of the Reconstruction Amendments on their own initiative. So in my view, you've got to address just how rough the road to giving these theories that force of all will be. But you can't end with that pessimism. It doesn't help anything. It doesn't help my two daughters. You've got to look at how we might start to build towards those longer-term victories through litigation, organizing, and activism. That can all start at the state level and build to eventual federal victories. There are potential analogs to the 13th Amendment in state constitutions that can support involuntary servitude and badges of incidence arguments in state courts. They don't all have the same language. They don't all have the same origins. But are going to have to be approached one at a time. Some states prohibited slavery early enough that it hadn't developed all of its eventual nasty characteristics, so a badge of incidence argument might not work in those states. But others wrote their constitutions in the abolitionist era and with that intent. And so many copied the involuntary servitude language that it could form the basis of a long-term litigation strategy. And of course, that's before all the efforts to amend state constitutions that may create a better legal environment for reproductive freedom in coming years. So there's room for optimism, but you're going to have to dig into the details of why. And there is no one better to do that than you, Rebecca. Thank you for sharing your draft with me and allowing me to comment.
Thank you, Brandon, for blending the pessimism and optimism there. Okay, so we're a little late because of all the technical issues, but we do have until about 10:55. So let me take a few questions, and I also promised the speakers they'd have a couple of minutes to respond to commentators. So, yeah, just to introduce yourself. Yeah,
I'm Rick Levy. I'll be on the next panel.
Yeah.
I'm going to the examples of countries with constitutions that prohibit abortion rights and the developments in Mexico and Colombia. Have you thought about the German experience, where the German Supreme Court originally held that the Constitution required the government to criminalize abortion and then backtracked, eventually relaxing that view? How would you, I guess, compare that experience to what happened in South America, Mexico, and those areas?
You want me to respond, or do you want to? Yeah, no, I think that these decisions actually, I think that they actually may have actually cited the German case. And just to be clear, it's not actually that abortion rights are prohibited, but that under these constitutions, there's an affirmative obligation to protect prenatal life, which, again, it's not a right of prenatal life, and it's an obligation. And I think it's a different constitutional structure where there are affirmative obligations. But I think the German Constitutional Court, although it didn't require it, I mean, there was actually a lot of discussion about developing programs to help pregnant people, right? And there was like creating labor protections, creating tax incentives, all of these things actually to try to make people want to or support people in helping them to choose, if they want to have children, to feel like that they can continue pregnancy. So I feel like, it's a different kind of discussion, but similar. The other thing I want to note is that in these cases, and I think in the German case, there is discussion about counseling, right? And this idea of, we are going to work together with the pregnant person and support them and their autonomy, but there's this idea that we're going to provide counseling, right? And in theory, they talk about sort of, I think letting a pregnant person know you could get these benefits and there's the support for parents is helpful and fair, but a lot of times we know that counseling is actually used to sort of in a coercive way. The Mexican Supreme Court says that there should be the provision of information, but it needs to be truthful and non-coercive, and that there shouldn't be delay. But there's still a little bit of this overtone, which I feel like we saw in Casey, that maybe if people really knew, they might, not choose to have abortion. So there is that overtone, and I think when the high courts talk about counseling as a way to protect prenatal life, it's sounding a little shaky to me. Yeah.
We're using a mic just so they're recording this, so we want to make sure we can hear it.
Thanks. I'm Christine Ryan. I'm based at the Law Rights Religion Project at Columbia. Sorry to go to you again, Cindy, but my concern with international human rights law, aside from the fact that federal courts here have plenty of disdain for it, is that the law has developed based on a logic that any of the rights you're protecting are tied to this idea that you need to prevent unsafe abortion. Even most recently, when the Human Rights Committee finally addressed abortion as an issue of equality at the examination of the US, again, the recommendation was tied to legalizing abortion to prevent unsafe abortion. In reality, we all know abortion is extremely safe. And this has been shown even when it is, even in where abortion is criminalized, people access safe abortion both in a dignified way and a very safe way. Not that I expect you to have, an entire solution to this, but how do we bridge that? Because of course we're worried about, the bogus studies that emerge saying that abortion isn't safe, but do you have any concern there?
Yeah, thank you for raising that, because I feel like, even in discussions that we've been having in the United States, some people were bringing back the coat hanger, and I feel like it's, we don't want to reinforce this idea that self-managed abortion is unsafe. But I guess there's sort of two things that we need to hold at the same time. One, I feel like internationally there really is a long history and evidence that over-restrictive or criminalization of abortion has led to unsafe abortion and high rates of maternal mortality. I think we're in a different situation in the United States because of, and some of those statistics are older, but just because of the availability of medication abortion, right? And which means that people can safely self-manage outside of the formal medical system. But I think we need to recognize that in order for people to actually access medication abortion, there have been tremendous efforts in terms of websites and people making people sure that people get pills, all kind of in this quasi-legal space, and also this tremendous network of people ensuring that people can travel to other states, right? So it's actually like all of these workarounds, I feel like, that have mitigated the harm potentially caused by criminal abortion restrictions, which means that, thank God, we have not seen a lot of what other countries have seen. And I do think also, even if people can safely self-manage, they shouldn't be forced to have to do that outside of the medical system. And there are still very real harms that people have experienced, even if it's not the same high rates of maternal mortality in other countries.
I'm going to take Katie Young's question next from Boston College. Yeah, just wait for the mic.
Great, yeah, Katie Young, Boston College. I really enjoyed this panel, and I really appreciate the way all of the papers, both papers and the comments, are playing offense and defense here. But I was just curious as to the reference in Dobbs to human rights. Justice Alito references human rights in a way that doesn't connote international human rights understandings, but a very different religious, categorical, very natural rights kind of scope. So I wonder how concerned you are in the reference there in a constitutional decision to an untethered human right to life on the part of the fetus. Whether you see that as something to be taken on head on or kind of ignored, willed to ignore.
Yeah, it's funny, we were talking about this earlier, and I feel like myself and Martha Davis and others have really talked about the history of the human rights movement in the United States and how, going back to discussions about slavery, right, this idea of bringing this concept of human rights, which is not necessarily recognized by domestic legal system, and using it to challenge the domestic legal system. And that's sort of what Alito seems to be trying to do here, right? Because there's no originalist support, I think, for this idea that, the fetus is a person, right? And there's no, and also in international human rights documents and jurisprudence, it's clear that the fetus is not a person. So I guess that I would, and I wrote a paper where I sort of pointed that out, But I do think you're right that that's what is going to happen. And it's ironic because you have these conservative justices who talk about originalism and who talk about we don't want to be influenced by international law or anything that's outside of the four corners of the Constitution. And yet you see that he's really teeing up this argument that there's some human right inherent in that the fetus has human rights. And the other thing I'll just say about that is historically, and the thing to watch out for is historically when we make human rights claims, they're about people, right? It's actually advancing their autonomy and their autonomous choices. And when the anti-choice movement talks about fetal personhood, it's not actually about furthering the choices of the fetus because the fetus can't make any choices. It's actually expanding the power of the state. So I feel like that's like an argument that could be made.
Is there any question for Rebecca? Okay, Caroline.
Thanks. So I love the thought of using the 13th Amendment. It seems to me that among the obstacles to using it is first, as a sort of forced labor, is first women's labor tends to be really invisible. So to even get people to acknowledge that there's some labor going on in the first place is a stumbling block. And then the second is the idea that, well, if a woman's going to have sex for pleasure, then she should be prepared to become pregnant and become a mother. And so I think both of those are very deeply ingrained in our culture. And I guess my question to you is, what do you think the best ways of overcoming those two sort of related obstacles are?
Feminism. I do think that talking about the history of slavery is a way to sort of, make this clear. Enslaved people were the only reason why they existed as far as their enslavers were concerned was to provide labor, and so the labor was everything. They worked in the farm, they worked in the fields, or they worked in the house or whatever, and they also gave birth and they also had to take care of their children. So sort of putting it in that context, I think is really important. So the invisibility of labor is, as you know, that's been something that feminist movement has been, talking about and attacking, for as long as there's been a feminist movement, basically. It's certainly, especially second wave feminism. So, what was the second question about? I just think that's a bad argument. I guess I don't know why it's a challenge more to to my strategy than to any other strategy. And of course, the men had sex too, but they don't have to. That's where sex equality comes in. They don't have to suffer the same consequences of having the sex for fun or whatever. Yeah.
One hand, yeah. This is going to be the last question.
So I have a related question on behalf of the litigators in the room because, and this is for Brandon and Rebecca, we see the appeal of the 13th Amendment arguments, but when we think about bringing a 13th Amendment lawsuit in this federal court system, we get a stomach ache. And so I'm wondering what your reaction is to that.
Yeah, and so I'm glad you asked that question because that's one of the things I wanted to talk about. So all rights in this country have, for the history of this country and probably for the history of humankind, have only come about as in part as a result of a political movement, politics starting from the ground. And actually I'm not a courts fan, I'm not a litigator. In fact, all of my work is about obtaining rights through the political process, but not just, and Brandon's absolutely right about the dysfunctionality of Congress. I'm talking about starting at the grassroots, changing the narrative, like the forced birthers did with Right to Life, So that's what I'm really talking about. And also maybe, yes, achieving some victories at state levels, but no, please don't litigate in federal courts, because then we'll get really bad precedent that'll cut it off at the beginning. And Mark Tushnet wrote a great book about this, and Martha talked about, the movement to get a right to a right to life, a right to welfare in the courts, and how that failed, and what Tushnet argues in his book is that sort of cut off the political argument, which came very close to passing a federal law that established the right to a sustainable. What was it called again, Martha? Do you remember? Guaranteed minimum income, that's it, a guaranteed minimum income. So I want to make it very clear, I'm talking about at the grassroots level, and which is what the reproductive justice movement is, a grassroots movement. I'm, of course, yes, I am an optimist, as Brandon says, and I always will be, and I'm also a realist, but I just want to say that the same year that the Reproductive Liberty Amendment was on the ballot in Vermont, there was also an amendment to amend Vermont state is very proud that they were the first state to ban slavery in their state constitution, but it had an exception for basically for people who were bound as indentured servants under age of 21. And so the same year that Reproductive Liberty Amendment was on the ballot was also an amendment to ban slavery in Vermont. And that's when I met Brandon, when this was all on. So both were on this ballot, both passed with over 70% of the vote. And in Vermont, which is quite it's a very blue state, it's a very rural state with a lot of conservatives as well, but the Reproductive Liberty Amendment passed in every single town in Vermont. And Jesse, I think, is going to talk about Ohio later. And Ohio, the state of Ohio, which is trending redder, passed a constitutional amendment, abortion rights amendment last fall. And as to the tie with democracy, there was a very interesting tie there in Ohio, where the state, the anti-choicers, or as I like to call them, the forced birthers, tried to change the process for amending the Constitution, which was resoundingly rejected by the people of Ohio. And I would be very, very remiss if I didn't mention that even as we speak, the United States Supreme Court is hearing the argument incredible. And I hadn't thought about how in Dobbs they never even talk about the anti-slavery activists who, I mean, the Reconstruction Amendments have major power for rights and liberty in our country that has never been enforced. The 13th Amendment is definitely one of them. So I just wanted to say that as well.
Brandon, do you have anything you want to say?
Can you hear me? Can I add as a quick word? Okay, awesome. Look, to the litigators in the room, it's not enough for us to say, don't do that, right? Your client, people you care deeply about, something was taken away from them, right? They want something, they seek justice. I think there are avenues on the state realm. I think there's possibilities. I think there's possibility in terms of advocacy for what type of jurists we want to be putting on these benches, what they should look like, where they should be coming from, their backgrounds and movements, what are they bringing to the table? I think those are very important questions. So sure, you're going to get bad precedent. I completely agree with that. But people are hurting. People need something. And my last comment is to all the students in the room, we need you. We need you. We need you. We need you. Thank you all.
Okay, welcome back, everyone. I'm Nicole Huberfeld. I'm one of the co-directors of our program on reproductive justice. I am a professor of law at the law school and Utley professor of health law at the School of Public Health. It's really a pleasure to have such a robust turnout, and we have so much incredible combined expertise in the room. It's really a thrill to be a part of this. So this is panel 3. This panel is constitutional principles, state and federal. I will very quickly introduce our speakers because we have more speakers and commentators on this panel than maybe any other. And so we're going to do our best to stay on time and keep plugging along and keep absorbing lots of great knowledge.
So first we'll have David A. Carrillo, a lecturer in residence and executive director of the California Constitution Center at Berkeley Law School. We also have his co-author, Allison Macbeth, senior research fellow at the California Constitution Center at Berkeley Law. And commenting on their paper is Richard E. Levy, the J.B. Smith Distinguished Professor of Constitutional Law at University of Kansas School of Law. After that commentary, Rick Levy will turn around and present his paper with commentary from David Carrillo, conveniently. Third, we'll hear from Caroline Mala Corbin, Professor of Law at the University of Miami School of Law and affiliated faculty with the Social Justice and Public Interest concentration. Commentators on Caroline's paper will be David Schraub, who had to join us virtually, an assistant professor of law at Lewis and Clark Law School, and Kathy Cavaney, the Darrell and Juliet Libby Millennium Professor at Boston College Law School with appointments in the Theology Department and Law. And then finally, though Catherine Franke was unable to join us due to travel snafus, we are very lucky to have Dr. Christine Ryan joining us, also from Columbia Law, at the Law, Rights, and Religion Project. And Christine Ryan is the Associate Director for Religion and Reproductive Rights at that project. So, without further ado, I'll invite David to get us started.
Turn to Allison.
So good morning, and thank you for having us. We're delighted to be here. Our paper that we presented really was born from a couple of different concepts: history and tradition, perspective, and religion. And beginning with history and tradition, after reading Dobbs, one of the compelling things, of course, that stood out was the history and tradition that the decision discussed and looked at. And there was also the decision from Bruin on the Second Amendment that focused on history and tradition. And at the same time, California quickly responded to Dobbs and drafted a constitutional amendment to codify whatever went by the wayside as a result of Dobbs. And this fortified what we had in California, at least statutorily. And that's where our perspective came in. California's Reproductive Privacy Act states that no law may deny or interfere with a woman's right to choose or obtain an abortion before the viability of the fetus. And in California, there's this balancing that takes place between the competing interests in procreative choices. For abortion, there's the person's right to privacy, which includes the right to determine whether to carry a pregnancy. And that state interest tips at viability on the state interest in protecting future human life. Now, one of the things that we've thought of in other contexts is the law of homicide in California. Homicide, under Penal Code Section 187, prohibits the unlawful killing of a fetus. And so you wonder, okay, how can that be? And there's actually no conflict because of perspective. When a pregnant person decides to carry that fetus to full term, that interest aligns with the state interests in protecting a person and protecting maternal health. But another person's interest in terminating that pregnancy, that third person's interests, conflict both with the pregnant person's right to carry out that pregnancy and the state interests in protecting maternal health. So perspective, we're looking at the interests of the pregnant person, not potential life. And that's where religion came in. We thought also about abortion itself, and it's often been reviewed as a medical decision, when abortion should be allowed, viability, et cetera. But at its core, it's really a question of religion. Any regulation about abortion is fundamentally based on a religious perspective. When does life begin? Is it a sin to have an abortion? And when there's these abortion bans, there is a favoring of one religion that draws the line of where an abortion can and should occur. And so it's a question of religion. And
we discovered in Judaism, it has viewed abortion morally acceptable in many situations and religiously required in others, and it's been historical. There's a historical perspective on this, and that's what we've outlined. So it's religion plus history and tradition, and so our perspective was that an abortion ban founded on religion and in conflict with another religion is not merely incidental. It's not an incidental effect of a generally and otherwise valid provision. So we look to history and tradition, perspective, and religion, free exercise, and that was where our argument came from. Turning it over
Is it
to
my
Jeff.
turn?
Yes, sir.
Who are the litigators in the room? Okay, y'all are my people. Comrades, we're here to help. So our perspective on this was we wanted to give air support to litigators who are looking for tools in the box, arguments to put in a brief in court. So rather than looking for reinventing the mousetrap, importing foreign laws, or generally creating a new theory and being novel about it, which we know the courts are rather reticent to do, we try to look at it from the perspective of what about this works? What can we make work? And we tried to apply the judo principle of using the opponent's weight against them. And there are some rather weighty principles that as a state constitutionalist I find myself fighting against a lot. Lockstepping, supremacy of federal religion doctrine, and state statutory RFRA provisions. Those are usually a problem for me. In this article, happily, we get to take advantage of them. I will concede at the outset that our argument is not exactly new. The ACLU has been making a version of this argument in state litigation for the last year or two. So rather than taking the perspective of, we're bringing a novel perspective to the field, we want to provide support for people who are making that argument, give you a doctrinal build-out of that argument that you typically don't have time or space to do in a brief. So please feel free to plagiarize ruthlessly, copy and paste wholesale from what we wrote, use as much of it or as little of it as you have space for, and when it gets published, please cite to it as scholarly support for the argument that you're making in court. So we proceeded in 3 steps. One was we take advantage of the fact that most state Supreme Courts lock their state constitutional individual liberty doctrines to federal law. That's good for us in this instance because federal First Amendment free exercise doctrine is beneficial here because it provides for strict scrutiny for laws that discriminate on a religious basis. I made friends with a rabbi who's been making the argument for a couple of years now that abortion laws discriminate against religions, Judaism in particular, which has literally thousands of years of Talmudic law tradition that define a fetus as not a person. It defines it in terms of being merely like a part of the pregnant person's body. One mentioned in the Torah calls it as being like water. So there's a clear doctrinal liturgical requirement in Judaism and in some other religions, particularly when the health and safety of the mother is at risk, to value the life of the existing person over the life of the potential person, the unborn. And laws that prevent that, we argue, discriminate on a religious basis. And then lastly, we're assuming that this argument is primarily going to be made in state courts. And if you are in state court, A, you have the lockstepping federal supremacy argument, and B, even if that fails, or as a backup argument, you can rely on the state statutory RFRA provision, which also provides for strict scrutiny based on undue burdens that are placed on religious practices, which again, abortion is a religious practice in some instances. So Professor Levy correctly points out that one critique of our argument is relatively limited in scope. It does only apply in the religious context. So, not exactly good news for the atheists out there, but so conceding the truth of that, I think I would close by saying there's an old saying that there's no atheists in foxholes, and in this instance, faith may be the path to salvation.
Okay, well, that was remarkably brief. for a law professor, so congratulations on that. I guess I agree with a lot of the analysis in this paper. I think there is a powerful free exercise clause argument that can be made in favor of abortion rights, at least for persons of Jewish faith. I'm not sure it's automatic, though, at least under current doctrine as it now stands. We still have Smith. I know a lot of people think Smith is going to be overruled. But until Smith is overruled, in order to get to strict scrutiny, you generally would have to show either that the law is not generally applicable or that it is targeting religion in a discriminatory way. Now, I think because abortion bans typically have some exceptions built in, under cases like Fulton versus City of Philadelphia, there's an argument that they're not generally applicable. And if they're not generally applicable, then that might trigger strict scrutiny. I'm a little less confident that laws that prohibit abortion target Judaism as a religion, as opposed to upholding the moral views of a particular religious faith. I don't know that laws that are adopted for moral reasons automatically discriminate against religions that don't share those moral beliefs. Laws against murder generally further a moral belief of many religions that murder is wrong. I don't think that means they discriminate against all other religions. I don't know how many religions favor murder, but I don't think that a law prohibiting murder is unconstitutional as applied to a religion that might believe in human sacrifice, to the extent that there are any left that do that. So I'm a little concerned that it's not automatic that we would get to strict scrutiny, and that that would automatically require exemptions. I guess I also, as other people have documented, I don't have a lot of faith in the neutrality of judges and justices these days. And even if there was a burden on a religious practice, it wouldn't surprise me if a court were to hold that there's a compelling governmental interest in prohibiting abortion and find a way to uphold the law in that way. Even if we got to the point where there were exceptions, as mentioned, I'm not sure how many people this would end up helping. Partly because Judaism is not a very widespread religion, but also partly because this may not always kick in, just like the right to physical life might not always be threatened. I started to think about Jewish doctors, because it seems to me that the religious argument is not just about the religious views of the pregnant person, but also about the religious views of the healthcare provider, and whether the right might be broader if we focused on healthcare providers in that context as opposed to only pregnant person. But then I started to wonder whether that might not end up encouraging legislators to target pregnant people if Jewish healthcare providers are then freely available to provide abortions. Then the solution to many legislators might be to make it a crime for the mother to have the abortion. So I'm not 100% certain how all of that would play out. I have two other larger concerns, I guess, that I would want to articulate. I appreciate the judo analogy. On the other hand, I don't really like the current approach to free exercise doctrine, and I'm not sure that I want to give much encouragement to a world in which every person's religious belief becomes a justification for an exemption from otherwise generally applicable laws. So I'm a little concerned about that. And then finally, and I was somewhat hesitant to bring this up, I am a person of Jewish heritage, and I worry that making this argument, particularly as focused on Jews, would open up anti-Semitic reactions, particularly given historical tropes about Judaism, and the correlation that we sometimes see between anti-abortion groups and anti-Semitism. So those are just some thoughts in response to the paper. I did really enjoy it, and I think it's an important argument from a litigation perspective. As a broader response to the problem of abortion, though, I'm not sure I am comfortable with it.
Thank you. And just to create a break in the commentary, thank you. And now we'll hear from Rick on his paper.
Okay, the reason why I'm really here is because I'm from Kansas. And there are very few points in time in history where the whole country and maybe the world were paying attention to what was going on in Kansas. But in the aftermath of Dobbs, that was one of those times. So as some of you know, in a case called Hodes and Nauser versus Schmidt, before Dobbs, the Kansas Supreme Court recognized a fundamental right to terminate a pregnancy under the Kansas Constitution. The Kansas legislature, which is very red, very anti-abortion, proposed a constitutional amendment that would overturn the Hodes and Nauser decision. They scheduled it in August on the assumption that primary voters would not turn out except the sort of strong Republican majority right-to-lifers. And all of that got turned on its head by Dobbs, when, as a result of Dobbs, really the amendment became the first political test of abortion politics in the new era. And I think I thought there was a chance that the amendment might be defeated, but I was stunned, like many other observers, that it was defeated by 60% margin, roughly. And to put that in perspective, in order to propose the amendment, there was a supermajority of legislators in both the House and the Senate. So it was really striking that 60% of the voters disapproved an amendment that was proposed by two-thirds majorities in both the House and the Senate of the state of Kansas. So all of that background, I think, is very interesting. I have sort of three observations about those events that would be relevant to this conference. The first is that the pregnant person's right to life was basically invisible in the Hodes and Nauser decision. Section 1 of the Kansas Bill of Rights provides all men are possessed of equal and inalienable natural rights. Notice it says men, among which are life, liberty, and the pursuit of happiness. Now, the court in Hodes and Nauser emphasized the text and history of Section 1 to justify providing greater protection for abortion rights than under the federal Constitution. What I found really striking when I thought about it was that the court emphasized the textual reference to inalienable natural rights, talked about how that invoked the Lockean tradition of natural rights. And the court also then specifically mentions liberty and the pursuit of happiness as the source of rights to bodily integrity, autonomy, and rights related to children and family, all of which supported the right of a pregnant person to terminate a pregnancy. Well, what was missing there, the court just kind of skipped over the right to life as a textual foundation. And I thought that was particularly striking because the law in question in Hodes and Nauser was a late-term abortion ban on certain procedures, D&E type procedures. And the court, in applying strict scrutiny, emphasized that that increased risk to the life and health of the pregnant person. So the right to life was front and center factually in the case, but basically completely absent from the court's discussion of the pregnant person's right to terminate a pregnancy. So that's observation number one. Observation number two is that the successful campaign against the abortion politically centered the life of the pregnant person, both the physical life of the pregnant person, but also the life of the pregnant person and how it would be impacted by the ban. Now here, the lawmakers ironically entitled the amendment the Value Them Both amendment, purporting to value the lives of pregnant people as well as the unborn child in their terminology. But there was nothing in the amendment to protect the life or health or interests of pregnant people. There was language that said the legislature may make exceptions for the life and health of a pregnant person or for cases of rape and incest, but it was the legislature may. There was no language requiring any exceptions in those cases. And everyone knew that in Kansas, if the amendment passed, the result would be total or near total ban on abortions. So that made it pretty easy as a political matter, as a matter of advertising, to highlight the consequences for women if the amendment passed. It made it easier to argue the weight of the pregnant person's interests as being commensurate with or greater than the weight that the state was attributing to the life of the unborn child. Of course, there were news accounts that were going on in other states, particularly at that time, the case of the 10-year-old minor female, I don't know what you call them other than that, was front and center at that point in time. So I think that although there were a lot of factors that contributed to the outcome, I think centering the life of the pregnant person made a big difference politically to the defeat of the amendment. And then that brings me to my third observation, which is there's an awful lot of work to do to get from the political salience of the life of the pregnant person to some sort of doctrinal reliance on the right to life as a foundation for abortion rights. Even as we think about the physical right to life, there's some support for the idea of a right to self-defense. That right might kick in if the state is depriving people of access to health care that is necessary to save their life or to prevent serious health consequences. But beyond that, I don't know that what we have gets us very far. As a person who used to study languages, though, I got kind of interested in the phrase life, liberty, and the pursuit of happiness. I've made a similar argument in other contexts about life, liberty, and property. We have a tendency to disaggregate those terms and to think about the right to life as one thing, the right to liberty as something else, the right to the pursuit of happiness or property is yet a third thing. But linguistically, I generally think that the phrase is a single item. It's, and it has a combined meaning that might gain traction for the right to life. If we start to think about the right to life not as a separate leg or a separate standalone right, but as part of a larger expression that references life, liberty, and the pursuit of happiness as essentially everything that is important to a human being in their existence, that might be a way to make the right to life more salient as a doctrinal matter. And I think I'll leave it at that.
So my comments on this paper are in two parts, because I saw the paper proceeding in two parts largely. I'm going to save the, much of this paper concerned kind of political commentary review about things that have happened and developments on the ground. I'm going to come back to that at the end. But on the doctrinal side, I think the paper functions primarily as a critique of some of the arguments that have been advanced on previous panels and that are arguments that are made in other papers here. And so I think it's useful from that perspective to challenge the contours of some of the basic assumptions that people are making about the relative values of legal arguments that we're talking about making here. So I think it serves a very practical perspective of holding up a mirror and showing the weaknesses potentially in some of these arguments. For example, I think there are three primary areas that the paper critiques the doctrinal strategies that are being advanced here. The first one is reliance on international law, which tends to be a weak read, frankly, and I think we need to admit that. If your lead argument in your brief is something that the UN has said, it's not the strongest argument, either in general or as something to lead with. And if that's all you have, that's quite a weak case, I'm afraid. And I think the paper correctly points that out. So more beneficially, we should be relying on domestic arguments that are fairly well trod. And here again, the paper serves up a useful critique of a couple of arguments that have been kicked around here already today. One of them is this idea of natural rights. Again, unfortunately, not the best argument. It's a little bit like relying on the 10th Amendment. It's there, it's a thing, and it won't go away, but it's an unreliable friend. And again, not the strongest argument. Natural rights have been around since the revolutionary times. It shows up in the writings of Thomas Jefferson and some of the other founders. John Locke was a very influential thinker at the time. So naturally, that it would show up in their writings. Unfortunately, natural rights, either in the John Locke framing or in the very traditional Roman law framing of natural rights, it's never really caught on. It has very little traction in the courts, and so there's very little precedential support for making a natural rights argument. So again, not the strongest argument potentially. The third area that the paper critiques is the nascent, to borrow a phrase, the nascent field of the right to life generally, either something that's rooted in a particular constitutional provision or as a novel right drawn from the penumbras, if you will. And here again, potentially not the strongest argument, according to Professor Levy, because arguably the only analogous area of constitutional law that has built out something like this that you could rely on is in the, it's sort of in the reverse. It's in the death penalty, capital punishment context, which is sort of the last place you'd want to look for right to life, right? And there are a couple of problems with the argument. One of them is that unless you're making an Eighth Amendment argument, which is probably not the best fit here, really what you're limited to is essentially a form of due process, which is not what you want to be relying on here, because essentially a due process argument is a concession that the government can take the action that it is attempting to take. It's just a question of whether you were provided with the necessary procedures in order for the government to take that action. So denying you the abortion is the ultimate result. Did you get notice and an opportunity to appear? So, again, in terms of achieving the intended result, perhaps not the best argument. But at the end, the paper sort of circles around to where this all started, which, to put it in Lockean terms, the right of self-determination, which in modern times, in modern constitutional discussion, is usually in the framing of privacy. And here there is good news, because even though so there's two basic problems with relying on federal privacy law. One of them is that it's non-textual. It comes from the penumbras. The other is the current state of abortion as a subset of federal privacy law is, as we know, it's effectively non-existent now. So under federal law, the paper is closing with a remark that it's hard to see how a justice that is unwilling to recognize abortion rights as within the more well-established rights of self-determination and bodily integrity and privacy would nonetheless find abortion rights to be protected by the right to life. So, again, arguing for a novel, more general right to life, perhaps not the best strategy. Instead, leaning into privacy, not under federal law, but under state constitutional law, is probably the better strategy. And the paper closes by, again, framing in the Lockean terms that the elements refer to the principle that each of us is entitled to live our lives without undue interference from the government. That is a very Lockean conception of the right to be left alone, which is the right to privacy. And the good news here is, again, I'm a state constitutionalist, and I try to keep it practical for my friends who are still litigating cases. Many state constitutions, like California's, have a constitutional right to privacy. We just used it in California to enshrine a specific right protecting abortion rights. Before that, all abortion rights in California, except for the statutory ones, the constitutional rights in California were all based on California's privacy right, which is a right to bodily autonomy. And we've been very successful with that. Contrast that, again, using California as an example, with the attempted use of things like natural rights. Natural rights were advanced by Governor Jerry Brown in attacking Proposition 8, the ban on same-sex marriage in California. California Supreme Court considered natural rights and rejected them out of hand. So natural rights have not been successful, at least in some instances. They're unlikely to be successful in the future, this paper argues. Instead, the better strategy is to lean into where all of this started, which is privacy, but arguably now on stronger footing because of the textual constitutional privacy rights that many state constitutions have. You're on safer ground.
Thank you.
Okay, and I'm timing myself as well, so not to worry. Okay, so I was particularly invited to present on religious challenges to abortion bans, and I will happily oblige. As you know, since Dobbs, around 18 states have banned abortion either from the moment of conception or around 6 weeks when the pregnancy is at most an embryo. These early abortion bans should violate both of the two religion clauses, which include the Establishment Clause and the Free Exercise Clause. Now, the reality is that the U.S. Supreme Court will never go for these claims, but lower courts might, especially state courts interpreting their own state constitutions, all of which have some version of an Establishment Clause and a Free Exercise Clause. So it's still worth reviewing how religion clauses may protect women's right to control their own bodies and their own lives. So the two religion clauses are actually meant to work together to promote religious liberty. The Free Exercise Clause promotes everybody's religious liberty by mandating exemptions from laws that might prevent people from practicing their religion. And the Establishment Clause protects the religious liberty of minority religions by barring the government from having a favorite religion, and especially by enacting that favorite religion's tenets into law. More specifically, the Establishment Clause has long required a primarily secular justification for any law. Because if a law doesn't have a secular justification, the government is acting like a theocracy, imposing some people's religious views onto those who don't share them. And bans of super early abortion is all about imposing one theological perspective on when life begins onto everyone else. Right? There is no legitimate secular justification for forcing women to undergo months of pregnancy and forcing them to become mothers in order to protect what is ultimately a cluster of cells, right? Maybe there's a persuasive secular justification for privileging a 7-month-old fetus over the pregnant person, but not an embryo. And if there's any doubt about that, right, the legislatures and the governors who are enacting these laws are not shy about boasting how their religious belief that life begins at conception motivates them to ban abortion and save the innocent babies. Okay, again, it's a no-go with the Supreme Court, right? The Supreme Court is never going to admit this, and in fact, they're likely to cite an earlier case rejecting an Establishment Clause challenge to abortion regulations on the grounds that a law that coincides with the religious tenet is not unconstitutionally establishing a religious tenet. After all, the Supreme Court argued, right, the 10 Commandments says, "Thou shalt not steal," and it would be ridiculous to conclude that laws against theft violate the Establishment Clause. Superficially, very persuasive, but ultimately sophistry, right? There are any number of secular reasons to ban theft, but there are no legitimate secular reasons to ban early abortion. They all ultimately collapse back onto the religious belief that life begins at conception. And it's entirely possible that lower courts interpreting the Federal Establishment Clause or a state Establishment Clause would agree. Indeed, at least one court in Kentucky already had, finding the state's ban to be a theocratic-based policymaker. So, possible Establishment Clause challenge. Doctrinally, it's actually religious liberty claim that is stronger under existing doctrine. So, under current law, religious observers are entitled to exemptions from laws, religious exemption from laws, if 3 things are true. All 3. First, the law has to target religion for disfavor. Second, the law has to impose a substantial burden on somebody's ability to practice their religion. And 3, the law has to fail strict scrutiny. Right? So all 3 things have to be true, but the current Supreme Court has made it so much easier to qualify for a religious exemption. At least it's made it so much easier for the conservative Christians who have come before them. Okay, so how does it apply to abortion? And your first think might, well, a law banning abortion doesn't really seem to be targeting religion. But wait. The Supreme Court has held that if a law allows for a secular exemption, if a law has a secular exemption, then it is targeting religion if it does not allow for a comparable religious exemption. So if an abortion ban contains any secular exemptions, like for health or for rape, right, then it is targeting religion under the current doctrine if it allows abortion for secular reasons, but not religious ones. So the first requirement can be satisfied if a law has some kind of exemption. Well, what about a substantial burden on religious exercise? And honestly, the reality is under the current doctrine, the Supreme Court has become so deferential to religious claimants that this is almost just a rubber stamp requirement. But if they chose to reinvigorate it, a religious objector like a Jewish woman may have a strong claim, and you've already heard some of that. Now, Judaism's not monolithic, but generally Jews do not believe that life begins at conception, and they're not the only ones by a long stretch. I'm Jewish, so that's the example I'm using. And also there are a lot of lawsuits brought by Jewish objectors. Okay, so under Jewish law, a pregnancy is considered part of the woman's body until birth. Moreover, Jewish law commands that if a pregnancy threatens a woman, either physically and in some denominations emotionally, it must be terminated. In other words, one well-established interpretation of Jewish law is that abortion is mandated in certain situations. So consequently, abortion bans may well deny Jewish women the right to practice their faith and end a pregnancy that harms them. So that's the second requirement. Finally, the bans should not pass strict scrutiny. What's the compelling interest to start with? Right? It can't be that these bans save lives, as again, this assumes that life begins at conception, something the Jewish lawsuits reveal is not a universal truth, but a particular religious viewpoint. I suppose it could be protecting potential life, but really to argue that it's compelling at all stages of pregnancy really still seems very much tinged with religious belief. In any event, it's not narrowly tailored, right? Laws with secular exemptions are not considered narrowly tailored, because if a law can accomplish its goal with a secular exemption, the court will say then it can also accomplish it with a religious exemption, and it's not narrowly tailored. All right. So again, it's hard, and this is all existing doctrine. I'm not being theoretical here. I'm just like, this is the law today, and it's really hard to overstate how easy the Supreme Court has made it for conservative Christians to get religious exemptions. Again, it's unlikely that the outcome-driven court will be as solicitous to religious objectors whose views clash with rather than further their own. Still, I think religious claims can meet with success in lower courts who feel bound by the existing precedent and don't think that religious liberty belongs to conservative religions only. So, to sum up, there is a very strong establishment claim because there's no secular justification for very early abortion bans, and there is particularly strong religious liberty claims given the existing doctrine. And these would allow women to live according to the dictates of their own faith and not be forced to live their lives following somebody else's. Thank you.
Thanks. Hopefully you can hear me just fine, and I'm delighted to be able to be joining you from the West Coast, and particularly to have the opportunity to comment on Professor Corbin and Carolyn's fantastic paper. I'm a great admirer of her work, and so I'm very pleased to have this chance. I'll state off the bat, my priors before reading your paper was I came in, as you might expect, agreeing with you on the free exercise clause, and I came in disagreeing on the establishment clause argument, and I finishing the paper, I still think that, but I was more persuaded by the establishment clause argument than I expected to. So it was definitely very challenging and very thought-provoking. I want to focus on my continued hesitations on the establishment clause, because I think that's where we have some separation. On the free exercise part, I'll speak a little bit, but a lot of it is just going to be to say, yeah, that. I think you're just right. I think that you've got it mostly nailed down there. But on the establishment clause argument, I think a large part of the problem here is something that has bedeviled First Amendment scholars, and kind of embarrassingly bedeviled First Amendment scholars for a long time, which is what makes something religious, or what makes something a religion? How do we know when an argument is or is not a religious argument? And there are a variety of kind of signposts that are talked about or alluded to throughout the article. And for a variety of reasons, none of them are fully satisfactory, and it makes it very, very difficult to figure out what makes something a religious argument and what is not. Fact of the matter, it's very obvious, and I think you're clearly right, that religious views motivate many abortion restrictions. That seems like an omnipresent fact in political activity in a nation that has a significant religious population, because legislators make decisions based on values, and many people's values, at least in part, stem on their faith. Yes, sometimes people are very upfront in saying that. In the case, as you mentioned, of legislators who say, this is why I'm voting for this abortion restriction. But you could also hear it when, a Jewish legislator says, Judaism teaches us to repair the world, and thereby are confessing their vote for a welfare statute as a closet effort to smuggle in a theocracy. I'm not so much convinced. So it can't just be the case that declaration of a religious motive makes an argument inherently religious. I don't think it can also be the case that anytime religions disagree on an issue, as Judaism and Christianity do, or at least in certain denominations appear to do, on the question of when life begins or when it's endowed with moral personhood. So what does make something religious? And core instinct here, and I think you cite Sherry Kolb on this, is to distinguish a religious view from a scientific view. But I think that gets a little bit shaky once we add a third category, which is that of normative views, right? Views on ethics, views on right and wrong. Because claims about human values are not scientific, at least in the normal sense. And they regularly undergird legislation nonetheless. So the example about for laws that criminalize theft, or why theft is wrong, protecting community members from financial or physical or financial harm, these aren't scientific reasons either. These aren't things you can see under a microscope. We need reasons to care about why harming people physically, financially, emotionally are problematic, and those reasons are not going to be deducible from empirical observations about the physical world. And so just as the old line goes, that the Constitution does not enact Mr. Herbert Spencer's social statics, it also doesn't necessarily enact John Stuart Mill's on liberty either, in terms of inherently privileging that particular notion of what values are right and wrong. Genealogically, as you say, there are obviously deep religious roots to thou shalt not murder, thou shalt not steal. And so I think that the core argument that's being put out here is a variant or an application of Rawls's idea of public reason. Because Rawls tells us that political arguments for the imposition of coercive measures must be justified by reasons which are at least conceptually accessible to all. And so it's not that any argument that has a religious basis for some is inherently impermissible, so long as the reasons reasons are ones that could be accepted, or the position is one that could be accepted for secular reasons. And examples of things that wouldn't qualify would be, we must do this because the God that you don't believe in commands it, right? It's not a publicly accessible reason. Any more than we must do this because it personally advantages friends of the ruling dynasty, right, is a publicly accessible reason. I know many religious scholars have criticized Rawls by suggesting it seems to put religion at a disadvantage in the public square. They need to gain a secular stamp of approval for their normative positions, even though the secular positions are equally non-scientific. But for me, I'm just not sure I can follow all the way down here. The view that life begins at conception is a view that could not be held for secular reasons, at least once we dispense with the claim that any non-scientific claim, which includes all normative claims, must be religious rather than secular. So I'm inclined to agree that the secular case for abortion restrictions collapses into some normative belief about when and in what contexts we value biological life, but that's not the same thing as showing that that view is inherently religious. And ironically, the drift we've been seeing in recent years of small c conservative right-wing Jews towards supporting more restrictions on abortion rights, which is a drift that seems motivated less by a return to theological first principles, since we've discussed that Judaism doesn't really take that line on abortion traditionally, but rather seems to be more about a political alignment with conservative ideology, supports the notion that these views can be held for and generated by secular political reasons and commitments. And if we're going for the more Potter Stewart style, you know it when you see it, full categorization of religious and secular subjects, the question of when does life begin, or maybe more aptly, when is a given clump of organic life endowed with the properties of moral personhood, feels like at least a candidate subject for secular philosophy, in a way that should I be forbidden from kneeling before a golden statue of an animal does not. So it's not that these views on these questions can't be religious, because they clearly can. And I think that that's very important for supporting the free exercise claim, which I think is doctrinally on very strong footing. I ultimately think, though, that the Establishment Clause claim is a little more tenuous, and relies on a notion, a way of separating religious from normative claims, that isn't necessarily going to be persuasive to the persons holding it, who I do think view this as more akin to the sort of hybridized, yes, I believe in opposition to theft for religious reasons, but also for secular reasons. And it's sort of skipping past that point. On free exercise, I'll just very quickly say that I agree with the basic point. Under the current free exercise doctrinal trajectory, abortion laws which carry exemptions, which is virtually all of them, must carry religious exemptions as well. I also agree with something that Rick said earlier, which is that I worry. I don't like that doctrinal framework, and I, think that it starts courting religious anarchy very, very quickly. But I do also think that what's good for the goose must be good for the gander. And if that is what the religion clause or the free exercise clause is promising, then there's no reason why liberal denominations, such as Jewish denominations, which I am as well, shouldn't be able to claim it. But I do think, while the results in this particular case are salutary, the risks of a hypercharged free exercise doctrine are very, very serious. And we do not want and should not want to live under a First Amendment Lochnerism framework. But ultimately, I think this is still an important argument to make, not so much because I think it's going to be successful in the courts, or at least the courts where it's most important to be successful, state courts in jurisdictions that have these draconian abortion bans. But I think there's value in laying loose the underlying hypocrisy. I think the practical payoff is more likely to be arresting the more extreme iterations of free exercise doctrine than it is to see meaningful reproductive rights protections extended in the places that need it most. But there is something to be said about laying that hypocrisy bare and showing at the very least that conservative Christians don't claim a monopoly on the terms of religious obligations in the reproductive rights sphere, and that the check that they claim to be writing as a general religious entitlement, I think, is very clearly one that Jews and other liberal religious minority denominations are not going to be entitled to cash. And making that argument and making that expressive and forcing that contradiction to the fore, I think carries a lot of value.
Great. Thank you very much for inviting me to respond to this fascinating paper. I just want to say I'm not wearing the sunglasses because I'm trying to be cool. It's not possible anyway, but I just had eye surgery, so I'm doing the best I can. It's very hard to follow that set of comments because there's going to be a little bit of repetition, but maybe from a slightly different perspective. I'm going to look at the line between secular reasons and religious reasons in the Establishment Clause context, and then say something about the Free Exercise Clause as well. But first, I want to kind of name, I think, the elephant in the room when you look at the history of the First Amendment religious clauses, which is really increasing moral pluralism, right? That's what we're facing here. So, when the Establishment Clause was written, they were mainly thinking about, no religious oaths for office, and no forced attendance at religious services. They didn't mean that you couldn't have, prohibitions based largely in the majority religion, which was Christianity. They just assumed, generally speaking, that Christianity and later what they called a Judeo-Christian framework would govern the country. So there was presumed to be a common morality that could be, enforced by the law without running afoul of the religion clauses. And that's really what's broken down, I think, in this nation. We don't have a common morality, and we don't have, I don't think, a sense that there is a neutral secular morality that we all agree on which you can plop different religious, like, widgets or secular widgets that would fill out the thing. I think we're in a situation where we think the
diversity goes all the way down, and that secular views are as contested and as unobjective as religious views, just in their own way. And I think a lot of the people who are opposed to abortion rights, including many members of the Supreme Court, have that view of what a secular view is. So in light of that, I think you have a couple of questions that might be worth thinking about strategically. One is, how do you draw the line between the religious and the secular, or the common, you might say, rather than the secular? One way, and it seems the paper adopted this approach, was to say, well, who's holding the view? There are a lot of people who are religious who are opposed to abortion, therefore it must be a religious view. But the trouble is, if you start looking at the data, it's much more complicated. If you look at Catholics, they're very divided about abortion. I can think of, as a scholar in religious studies, 2 or 3 very good books by Orthodox Jews which oppose abortion, except in situations where in which it's called to save the mother's life. And that's extraordinarily important, but that's probably not what the agenda of this particular conference is. So there's a lot of, complications that you look at that. Plus, I think it might be a backlash to people if you say, well, you're not entitled to express opposition to a particular point of view or support for a particular, because you're Catholic, because you're Episcopalian, or because you're Jewish. And then you get into a situation where we rule one another out on the basis of our religious identities. And for religious people, the religion cuts across liberal and conservative lines. You have Catholics who are very much opposed to the death penalty based on their religious beliefs. You have Catholics and Christians, including evangelical Christians, working at the border to save immigrants on the basis of their religious beliefs, not only their religious beliefs. So then I think you need to move to what sort of argument, and this was mentioned in the prior situation, that somebody is raising for the views they proffer. And many people who are pro-life will raise views that they believe are not drawing upon particular religious views, but some sort of understanding of common morality. John Rawls was mentioned, and even in the Political Liberalism, in a footnote, he said, well, many of the Catholics who are bringing forward views against abortion, I totally disagree with them, but they're not relying on religious beliefs to do that. So I think that making the case that this is an establishment of religion, when we're all fighting about so many things and so many people have so many different views, probably is not the way to go. I think the free exercise claim is much more interesting and bigger, but I also agree that this current Supreme Court is probably not going to be sympathetic to it. And the reason is, I want to pinpoint one element of the First Amendment and of the free exercise analysis. So you have to show, if you're a plaintiff, a sincere belief and a substantial burden on your free exercise. And I think somebody claiming on the basis of their religion that they have a claim to an abortion can make that argument. I think normally, so far in the free exercise claims, on behalf of conservatives, the court has sort of looked grudgingly at the compelling state interest claim on the behalf of, say, the government's claim to provide contraception. There's a lot of snarky remarks in Alito's Hobby Lobby opinion about the government's interest in this. So what I wonder is, if the pro-life movement succeeds in litigating these things, and you're dealing with somebody who is basing their claim to an abortion on religious freedom grounds, whether the Supreme Court will all of a sudden start assessing the compelling state interest claims in ways that are much more robustly favoring the government. It has not done that in the past, and I think that's where the fight will be in the future, is how generous will the court be in assessing the compelling state interest. Thank you.
Great. So firstly, I have to say, impart a message from Catherine Frankie, who is really disappointed not to be here, and we have to lay all the blame there at Delta Airlines. So thanks for having me. So I work at the Law Rights Religion Project at Columbia Law School, and we're involved in what a lot of people here are talking about is free exercise and establishment claims being made by persons of faith and not in state courts around the country. And there are a couple of things that I will say about, positive things that are happening there, and then some concerning things. And one of the initial points I want to make, and this idea was raised in some of the papers as well, is that we don't need to be beholden to the idea that the reason abortion restrictions impact free exercise rights is because abortion is, for some, a religious requirement. That is not what is required or needed as a matter of law. A religious practice doesn't need to be required. Consider Coach Kennedy, who felt that, he needed to be praying in a certain place. He, at one point, said he got that notion, felt that God told him to do that after watching a movie. So the burden on him was very minimal, and there's a risk that in consistently repeating a narrative that abortion is required for some people and that's why it burdens free exercise is in placing a higher burden on religious minorities. And it also presents an image of religion that doesn't really correspond to reality. For some, people, religion is an authority that does dictate everything in their lives, and that there's a command structure to it. But for others, and I think David in his other work really describes this quite powerfully, is that religious tenets, how they are operationalized by people, is in their personal decision making, and they're directed to do something based on how they think about their religious practice for themselves. And another, important thing to say around, why plaintiffs do have to explain why their conduct is part of a religious exercise, but it really doesn't have to be a compulsory rule. And the legislative history of the Religious Freedom Restoration Act is actually really good on this. And sometimes another example that I often like to give is, nobody is required to become a priest, but we would have no difficulty conceiving of that as a religious exercise. So I think we need to be careful not to download the abortion exceptionalism that has plagued other areas of law, and this is a point made by Liz Sepper and Liz Reiner-Platt, into free exercise law, both because it advances a conservative approach towards religion and it's placing a higher burden on pregnant people. Another thing as well, a lot of the conversation is around Judaism, understandably, but not all the plaintiffs in these cases, whether it's Indiana, Missouri, Wyoming, Florida, Kentucky, in Kentucky they are all Jewish, the plaintiffs, but they're not all. There's Catholics who are dissenters from, the doctrine as it exists. There are spiritualists, people who follow different forms of Islam, and they are just as entitled to raise these free exercise claims. And again, we very much consider, we keep thinking about Supreme Court doctrine and even free exercise doctrine at the federal level, but at the state level, this is going well in many places. Particularly encouraging is the ACLU of Indiana case in Indiana. It's currently in the trial courts, but there even, at a trial court level, the Judge Welch said that, you know, there clearly was a religious exemption justified here. It's at the Court of Appeal level. Based on the oral argument, I would be shocked if that decision is not upheld, and then it'll go to the Indiana Supreme Court. But in other places too, we're seeing things that are encouraging for both RIFRA claims and establishment claims. So Serena mentioned the great Pennsylvania decision, where that was based on equality principles. However, both in footnotes and in the concurrence, the judges said very interesting things about religious freedom law. So in terms of the establishment case, the concurrence makes the point that even though the Supreme Court is unlikely to invalidate abortion restrictions under the Establishment Clause, the Establishment Clause could limit the range of interests that a state can advance to justify their actions. And this is something that Caroline points out as one of the strengths of the establishment claim. And in the majority, albeit in a footnote, it seems like they wanted to, you know, throw a bone for this to be explored further, where they point out that Pennsylvania does have an interest in maintaining government neutrality towards religious differences among its citizens. And what that tells me is that, you know, we have work to do in pushing our theories around why abortion restrictions violate the Establishment Clause, and maybe focusing on religious secular purpose. You know, take it on board very much what you've said, Kathleen, but in terms of Kathy thinking about how some legislators are quite open about how they wish to privilege their religious views, and that they are not being neutral in doing so. And at the state level, both in terms of abortion restrictions statewide and some of these municipal bans or restrictions on abortion, the legislators are really open about their religious motivations, and that they are trying to privilege the religions of some. So one of the last things that I want to say about establishment claims is just a concern that I had reading the first paper, which is excellent, from David Allison and Daniel, in terms of how the question arose around how states' reading of their own establishment clauses cannot differ, the point was made, cannot be greater or provide more protection against church-state separation than the federal establishment clause, or the reading at present. And the point that was made in the paper was saying that, you know, that's the case because of Espinoza, which, for those of you who don't know, is a case where the court said that Montana's state constitution's no aid clause could not be interpreted to provide greater protection for church-state separation than the federal law, because that law was impinging on the religious freedom of some. But in the abortion context, I don't think we have that burden, because we are talking about the government needing to be neutral towards this. You don't have the same burden in having to say this doesn't impact the free exercise rights of anyone. That's just something that we hopefully will talk about more. That is more or less the conclusion of my remarks, and thanks so much for having me.
Terrific. Thank you, everybody. We have about 6 minutes for Q&A before lunch begins. And also, if any of our paper writers would like to respond to any of the comments they've received, we welcome that at this time as well. So I know we need to share a mic to make sure that we can pick up the questions in the room. Thanks, Elizabeth.
Can I make a quick comment?
Please.
Yeah, so I do think the challenge for the Establishment Clause claim is that it's a religious belief. And I really do think that, sure, in theory, you might have a secular justification for protecting a zygote. But the reality is that in this country, the laws that are passed to ban abortion are trying to impose their religious, and it's a religious view that the zygote is a person endowed with rights and it must be protected. So I think there's a theoretical that we could have a lot of interesting discussions, but I think that the reality is that in the United States, this is religious law.
Hi, thank you to the great panelists and the morning's panel too. I am Amy Myrick, one of the attorneys at the Center for Reproductive Rights. So we so rarely have the chance to be with students and to get opinions on which of these theories might resonate more. We've talked a lot about how outside the courts, the political dynamics, and it's really you who are going to be making constitutional law into something that actually works. So we've heard about international law, 13th Amendment, religion claims, history and religion. So I was wondering if anyone has views that they might want to share on which of these has potential. And not going to doctrine, I'm sure there's so many complexities, but just what really resonates intuitively.
I know there are students in the room.
Nobody will think you're a gunner if you have a question.
Dead silence.
Hi, my name's Heather. I go to Northeastern, and I'm a 3L, and I'm very focused on constitutional law. So just thank everyone for being here. It's been a great experience. I'm not sure, kind of similar to David's point, that I really buy the argument that there isn't a secular reason for the belief in life at the stage of a zygote, just based off of, I think, people my age, I'm 29, typically don't tend to be as religious as their parents tend to be, and so maybe there's a difference there, but thinking that many of them don't go to church, many of them are not, strong religious believers, but I still do know many people who we have those kind of like one difference in our kind of medical ethics beliefs of like what constitutes life. Is it viability? Is it consciousness? I think there are many determinations of like that kind of aspect. And then one question I did have was on David's point about the right of self-determination and kind of the state constitutional rights of privacy, and what state constitutions you're seeing that don't have as strong of a privacy protection, and what are the options for those states?
That is a fantastic question, and it lets me back into a point that I wanted to make earlier, but I forgot about, so thank you. So I haven't counted, so off the top of my head, I don't know how many states have constitutional privacy provisions, but I know it's a lot of them. Because it's actually fairly common for state constitutions to have more and more specific articulations of individual liberties than the federal constitution, which tends to be a frame of government, broad principles kind of document. State constitutions in general are written with a very different context and style, if you will. So it's just more common. State constitutional privacy it's its own body of law. So I'll go count afterwards. I'll post something about it. But I do want to make a meta comment, which is that everyone in the room so far has been focused on legal doctrine, and if the overall intent here is to focus on succeeding in the states, which is where Dobbs has directed us to go, then there's another piece of good news buried in your question, which is to expand our frame of reference beyond litigating doctrine in the courts, because I know this is going to be a tough concept for people who practice in federal courts, but you can amend your state constitutions. It's a thing. Don't forget about that. It's also a thing that you can do it in about half the states by voter initiative. I know that's a shocker to all the federal practitioners of the court, but don't forget about that. So if you're having trouble with the doctrinal solutions, you can change the playing field itself by changing the fundamental law on which you rely. So if there is a state out there that doesn't have a constitutional privacy provision, I suggest you go to the ballot and add one, because you can do that.
there's actually a really interesting story about right to privacy in Florida. The Florida Constitution has a right to privacy provision, and the Florida Supreme Court has interpreted it to protect the right to abortion. Unfortunately, the Florida Supreme Court has gone the way of the U.S. Supreme Court, and it's getting really conservative. And so there's a challenge to it, and it's suspected that the Florida Supreme Court is going to say, oh, right to privacy? No, it doesn't protect the right to abortion. And as a result, there is another proposed amendment to the Florida Constitution trying to actually put the word abortion into it, and that it is protected for precisely that reason. So that sort of dovetails with the point.
The Vermont Reproductive Liberty Amendment includes the language, I don't remember exactly what it is, but it's basically reproductive liberty. So it's very, very specific, but also includes more than just a right to an abortion. But I was going to mention that Ohio has a very interesting constitutional amendment which gives people a right to make choices regarding their health care that was enacted in response to the Affordable Care Act individual mandate. And there's some interesting are you going to be talking about it, Jesse? Yeah. Jesse's been just so active on the Ohio State level. Anyway, so, I think there's a very strong claim under that. And I wonder if there are other states that have the same amendment.
Well, I can respond to part of that, which is thank you, Vermont, and your neighbor Maine, because California's Prop 1 essentially copied almost verbatim the text of one or both of those measures. I mean, the two of them are kind of the same, and California is essentially a carbon copy of those. And further to my point about direct democracy, if your state doesn't already have a right to health care or whatever else you want, you can just add that.
Unfortunately, we're out of time for this panel. I'm very sorry for that, but thank you to our panelists.
So welcome to our lunchtime roundtable. My name is Aziza Ahmed. I'm a professor of law here at Boston University School of Law, and I'm also co-director of the Boston University Program on Reproductive Justice. I just wanted to start by adding my welcome and thanks to all of you for coming today. We have some of our amazing donors and supporters here. We have fellow travelers from the Center for Reproductive Rights and Planned Parenthood and the AG's office, and we're so grateful to have all of you here. We have students from all over Boston, Boston College, Northeastern, Harvard, and of course BU. And you know, it's not lost on me that our program on reproductive justice is really carrying an important tradition forward, which is the very long history of organizing on women's health that's emanated out of Boston. And so I'm excited to be sort of a part of these moments, which I really think are historical in leading national conversations on the future of reproductive rights and so on. So I'm going to start by introducing our amazing panel. I had initially asked them to introduce themselves, but I'm a little bit worried that they're going to short shrift how awesome they are, so I'm going to do the introducing. And this is meant to be a roundtable, so we're going to, we're just going to do it Q&A style. I'm going to start by prompting our speakers and then have them respond. But let me first introduce everyone. So on Zoom, walking through a beautiful big building, we have Michelle Goodwin, who is Linda and Timothy O'Neill Professor of Constitutional Law and co-director of the O'Neill Institute. We have Mary Ziegler, the Martin Luther King Jr. Professor of Law at UC Davis. Both Mary and Michelle's work was invoked earlier in a presentation, so we've seen their faces already. We have Serena Mayeri, who is kindly on 2 panels today. Thank you so much, Serena. She's a professor of law and history at the University of Pennsylvania Law School. Sitting next to me is Jesse Hill, who's the Justice Burke Green Professor of Law. Did I get that right? Ben, sorry, I couldn't remember him. Judge Ben Green, Professor of Law, and who's really on the front lines of everything happening in Ohio, and so we're excited to have you here. Professor Erin Daly, who's Professor of Law and Director of the Dignity Rights Clinic at Delaware Law School, Widener School of Law. Katie Krashell, who's new to our Boston community. She's Assistant Professor here at Northeastern University School of Law. And we have Christina Trina, who is the Avery Cardinal Dulles S.J. Chair in Catholic Theology, and we're so grateful that you could make it here and you're willing to talk to all of us lawyers. Thank you so much to all of you. And I'm just going to begin by asking a question to our panelists who are on, to one of our panelists on Zoom, to Mary and to Serena. And Serena, we got to hear a little bit about your historical work this morning on the reproductive justice movement and how you're sort of thinking about how history gets mobilized. And Mary, your work, in the many books you've written, but in your most recent work on fetal personhood, really digs deep into, both of you dig deep into the various advocacy movements and how they've drawn on historical ideas to sort of set the stage for what a right to life means. And I just wanted to hear you reflect on this from the perspective, from a historical perspective, from your own work, from a historian's perspective. Thank you. Maybe, Mary, do you want to go first?
Sure. So thanks for having me, everybody. I guess I think that doing historical work in this field makes it clear that there's nothing natural about or inevitable about personhood language or right to life language belonging to the right. So if you are in the 1960s or 70s, there were lots of feminists talking about the personhood of women, right? And what we would now think of as other pregnant people. They were reasoning about what created a person, right? Whether personhood, for example, required not only respect for somebody's bodily integrity, but that one have bodily integrity. In other words, the sort of Judith Jarvis Thompson-esque physical separation of your person from other persons. And somewhere along the way, in the book I'm writing now, there was a point at which personhood became associated with conservatism, with fetal rights, and with fetal rights where there was a sort of, I guess, almost a kind of zero-sum game, where respect for fetal life was synonymous with taking rights away from pregnant people, and in fact was synonymous almost entirely with incarcerating people, right, with criminal punishment. And so I think the understanding this journey, right, from a point at which that wasn't true, when arguments about fetal personhood for other people were common, and when even conservatives didn't necessarily understand fetal personhood as synonymous with incarceration, to the point we are now, makes clear that I think it's worth having just the kind of conversation we're having here today about a right to life, or that is consistent with reproductive justice. Those kinds of conversations have been generative in the past, and I think you can see so far today that they have been today and will be in the future.
Sure. So, and Mary's work on this topic, which I've had the opportunity to read a little bit of it recently, is just really fantastic, and can't wait to hear more about it. I just wanted to mention a few ways that advocacy movements from the period that I primarily focus on, the sort of 1960s, 70s, 80s, but mostly the 60s and 70s, I think have a lot to say to the themes that we're thinking about today. And I think it's helpful to think about those movements as precursors to what we now call reproductive justice. Wasn't named that necessarily at the time. So movements that many people in this room have studied and been a part of in the past, movements for welfare rights, for example, that spoke to the value of motherhood, of caring for one's family, of having access to meaningful employment, but also the option not to work outside the home, a sort of revaluation of women's lives and people's lives, particularly low-income women of color, as embedded in families and communities and in a different relationship to the state. And so in some ways, those, I think, provide inspiration and fodder for thinking about some of the broader questions we've been talking about already so far today, the need to look beyond, certainly beyond abortion and access to abortion, though that's incredibly important, but also to look to what's necessary for people to flourish, for individuals, families, and communities to flourish. And I think there are also some precursors in terms of legal and constitutional arguments that are made during that period that draw on these ideas. Arguments made, as far back as prior to Roe versus Wade, that people are really trying to revive today, arguments that sound in terms of equality based on sex, but also based on economic and racial and other factors. And I'll stop there for now.
Thank you so much, Serena. And it would be great to hear more later about the way you're thinking about life as a thread between that sort of pre-reproductive justice work and our current moment. But let me turn to Michelle. Michelle, thank you for joining us. I see you're on the move. Your work has really connected in I think a really profound way the contemporary debates on abortion to ideas that began in Reconstruction and with the 13th Amendment. And I was wondering if you could lay that out for us. Tell us a little bit about how we can view our contemporary moment through a sort of racial justice history.
Well, thank you so much, and it's a pleasure to be with you. I wish that I could be with you in person. So I think it's important, even on the question of personhood, to understand that the earliest debates about personhood related to Black women and their children. The very first or earliest of American laws related to what one could call a reproductive justice, a reproductive rights aim. Those were the laws of matrilineity and also hypodescent, laws dating back as early as the 1600s that designated the status of a child, that the status of the child would belong to the mother. This ushering in not only what slavery would be like in the United States, but it also meant matters of trust in estates, that children would be disinherited from estates of their white fathers, but it also ushered in then the kind of social, if not legal, acceptance of rape and sexual assault against Black women. Even though there were laws that explicitly prohibited those things, you find the works of Thomas Jefferson. You could go on the website at Monticello and look at his papers where he says that, his preference in terms of stocking his plantation was not with men, but it was with girls and women because they turned a profit every year or two. And so if you look back at that time and you look at the early personhood cases, they actually involve people like Margaret Garner, who escaped from a Kentucky plantation, making her way to Ohio. And in that case, which is then fictionalized and beloved by Toni Morrison, but is based on real life person. Her case was not alone. There's Celia in Missouri at the very same time. These all come after the Fugitive Slave Act, although there were cases right before that too. And in that case, this is a woman who slits one child's throat. That child dies, is ready to do the second. When she's overtaken and she says, I will not have my children in slavery. I will not continue in this vein myself. What's interesting in that case is that her lawyers want her to be prosecuted for murder. There are lawyers that are appointed for her, and they want her to be prosecuted because they want to push this claim that she has personhood. And if she is a person, what might this mean for all other Black women who've been in her position, subjected to sexual assault, subjected to rape, not being able to defend themselves against that, even though white women could. And so we miss so much when we think about personhood as having its early vestiges as a time that begins in the 20th century or is in the 19th century and only relates to white women. It doesn't. The earliest personhood movements actually relate to Black women and girls, and of course, Black men too. The 13th Amendment becomes relevant because Garner's story, the story of Celia, and there's just a whole list of others. And then there's all the text that we have from all of the advertisements, literally thousands and thousands of them, many of which I have in an archive, but are easy to find. This becomes a kind of chief rallying cry for the abolitionists who are in Congress, such that what they are considering with the 13th Amendment and the abolition of slavery, it's the abolition of slavery and involuntary servitude. And their key arguments are looking at people like Margaret Garner, looking at Celia and many others who've been subjected to just these absolute horrors. And I'll end with this. Since this conference is in Massachusetts, Senator Charles Sumner from Massachusetts, he's beaten nearly to death in the halls of Congress just days after giving a speech about the raping of Black women and Black girls and how this is such a key ingredient of American slavery and why it must be stamped out. And so such relevance to where this conference is happening and relevance to the 13th Amendment and a conversation about reproductive justice, rights, health, and personhood. Thanks so much.
So I want to do 2 or 3 things quickly. The first one is to simply say that we got a sense of what would happen after Dobbs because of the Catholic ethical and religious directives of Catholic hospitals, which with hospital mergers affect more and more and more women, disproportionately women of color. And very often Catholic hospitals or Catholic affiliated hospitals are the only hospital, especially in a sort of semi-rural or rural area. So we're talking about inaccessibility of other care other than at Catholic hospitals, which are governed by directives that forbid just about everything that Dobbs allows to be forbade in states, okay? So for instance, if someone who is familiar with the Tamisha Means case in Michigan, okay, who was refused care and refused referrals at a hospital in Michigan because she was in the middle of a miscarriage and really could not get care until she developed a terrible infection. So these are already around, and actually fighting the battle on the legal side for abortion rights is not going to erase the ethical and religious directives. So when you're thinking about religion in the legal landscape, it's important to think about the rights of individuals and in the medical space, both patients and care providers. It's very important also to think about the impact that religious freedom for religious private institutions has on individual women, just pregnant people, right, we should say, right? So please think about your definition of religion that you're seeking, and think about what the impact of that definition will be on ERDs and on provision of care, not just on individual freedom, because that's key, okay? I want to say something about the Catholic space that I think is also true of our cultural space. And that's that on one hand, in the Catholic space and in the cultural space, we have the idea that you have all been talking about, an expansive, robust vision of natural rights. On the other hand, we have a legal or rule-bound kind of attitude that wants to avoid transgression of rules, okay? And those two things actually are in conflict within the Catholic space, and I think they're in conflict in a secular or public space. Why? Because if you want to avoid transgressing a rule, you just need a really clear rule, and you stay on one side of it and you keep your hands clean, right? And so that's what's happening with lack of provision of care to pregnant people now. The challenge with the natural rights, the robust natural rights argument, is that those are positive rights. Those are, in a sense, aspirational, right? We never fulfill them. There's always a way to do better, and very often, de facto, they compete against each other. We don't have the resources at every moment to fulfill all of them, right? And so a prohibition is quite clear. You can make a law and it says this, right? Now, you're lawyers, so actually asterisk, right? That's not the end of the argument, but there's something very vague and unformed about those natural rights. And those two things end up competing. Finally, with regard to the feminist approach, I think that one of the other challenges is that a rule-bound approach tends to think that it's always possible to avoid, and in my theological space I would call sin, right? It's always possible to avoid transgression. It must be possible to avoid transgression, right? And that is the focus on the actor. But if we turn it around in a feminist way, we're looking at people who are in an interdependent relationship on every scale, from the individual to the social, and global actually, right? And that means that there are people who have claims on us whose claims that we will never be able to meet. We are finite, and because of our finitude, because of situations of injustice, because of the unavoidable pressures and vagaries of the world, right? There might be an earthquake, there might be a pandemic, right? We will never be able to fulfill all those obligations to others. There will always be tragedy. There will always be something unmet. I'm thinking here about the Turnaway study, and I also want to, I'm sorry, on the ERDs, I forgot to thank the Law and Religion Project at Columbia. Some of you are affiliated with that. You do awesome work. Thank you very much. Okay, so the Turnaway study that said when women are denied abortions, lo and behold, their financial situation, their existing children's achievements, and their ability to get out of abusive relationships is reduced, right? If they are allowed to get abortions, their situations and their existing children's situations improve in comparison. So that means that finitude is a huge element of our calculation, and one must consider always not only that there will be loose ends, there will be unmet needs, there will be unfulfilled natural rights always, right? So that means in this situation of a pregnant person's welfare, even before we get to the pregnant person's rights, I think the common good requires us, and this is from a feminist perspective, to think about whose needs for care will be unmet if an adult is disabled or dies. What future and present interdependent relationships will be harmed? How will society be harmed by the loss or the loss or illness of that person, right? So choosing life for society means choosing the pregnant person first. And then we talk about the pregnant person also as themselves possessing dignity and autonomy and ability to choose their own vocation. So if we're looking at the entire social structure from a feminist perspective of interdependence and tragedy, we have to focus on the welfare of the pregnant person. And that's without even having talked about that person's individual rights. So those are some of the things I wanted to start off with, and that was sort of long.
No, that's really wonderful, and I have a lot of follow-up questions, but I'll hold them until later. But there's something about the unavoidability of sin that really gravitates towards. Erin, I also owe you a thanks for being on 2 panels today. We owe you a thanks. Thank you so much. And you know, you run the Dignity Rights Clinic, and so we wanted to hear you reflect on this question of dignity. And of course, there's deep connections in many ways to much of what Christina said, and help us think through how you frame the question of dignity when it comes to life, and in keeping with our theme from all day, the religious roots, if you'd like to go there.
Thank you so much. Yeah, my comments really flow very much from what Michelle was saying about personhood and just the way we think of personhood, and then also very much from what you were saying. And also from, things that people had said this morning. Martha Davis started us off asking us to think about the international community and how in the world as a whole outside of the United States, the right to life is considered to be the right to live with dignity. It's not just the right to breathe and to be alive, but the right to have a certain quality of life, which can be defined in all kinds of different ways, in all kinds of different contexts. Everybody gets to decide it for themselves, but it connotes some basic idea of a quality of life, right, in whatever way. So we can think about the right to live with dignity. And dignity itself is a term that sort of finds its origins in the modern human rights era, in the UN Charter, actually, which is designed not only to end the scourge of war, we don't have to talk about how well it's done on that, but and also to reaffirm faith in human dignity. And of course, the Universal Declaration of Human Rights picks that up and reaffirms dignity in the preamble in several ways, and then in its first article where it says all human beings are born free and equal in dignity and rights. And then from there it goes, it sort of not dissipates, but sort of spreads through the two international covenants and through many other international law documents, as well as into the constitutions of more than about 170 states. Keep in mind that there's about 190-something states in the United Nations. So to have this one single concept resonate in the constitutions of more than 170 nations is really quite spectacular. And what that means is that once they're in those constitutions, courts have access to them, right? And so there's a huge, huge, huge jurisprudence of dignity from around the world. And I'll talk about that in a moment. But first, I want to come back to the issue of constitutional texts. And I want to read to you just one provision and ask you what you think of it. And the provision is this: that an individual's right to personal reproductive autonomy is central to the liberty and dignity to determine one's own life course, and shall not be denied or infringed unless justified by a compelling state interest, blah, blah, blah. Does anybody know where that's from? Vermont. Just saying. And part of what I want to talk about is just sort of how we integrate it. What's interesting to me about that language is not only obviously connecting the concept of dignity to reproductive choice, but connecting it in precisely the way the courts around the world, constitutions around the world, are talking about dignity as related to the dignity to determine one's own life course. You see that language in so many cases from so many different countries, in so many different cultures. It's really interesting. When you look at the whole body of law, you see that dignity is talked about, first of all, as an absolute non-derogable right. So the state doesn't, outside the US, doesn't get to say, oh, we violated that person's dignity, we engaged in torture, but we had a really good reason for doing it. Once you've identified it as a dignity right, it is non-derogable. It's inherent, which means that you're not waiting for the state to grant it. It is just part of being born a member of the human family. It's universal, it applies to everybody, and it's inherently equal. Everybody has the same dignity, and that connection with equality is obviously really important in how we think about reproductive rights in the United States. It's also connected to all different kinds of rights, and courts that are talking about dignity tend to take sort of a plaintiff's perspective often. It's what you might think about as empathetic judging, where they're, regardless of the position of the judge, they're actually thinking, how does this law affect the life of the person? So when you talk about sort of the impacts of not having access to abortion, that's the way these judges are talking about it, looking at, well, what happens to the person who doesn't have this? So I want to read to you something else. This is from a case, from a recent case. At issue here is the inalienable natural right of personal autonomy, which is the heart of human dignity. It encompasses our ability to control our own bodies, to assert bodily integrity, and to exercise self-determination. It allows each of us to make decisions about medical treatment and family formation, including whether to bear or beget a child. For women, these decisions can include whether to continue a pregnancy. Anybody have any idea where that comes from? What court? Kansas. I got to say, I never thought I'd be quoting Court of Kansas, but there it is. So, and again, that language, you can, I mean, you know it's from Kansas, but it also just is so similar to the way the Indian court, the Mexican court, courts all around the world are talking about this. So I just want to make the point that when we talk about reproductive choice being so much about these issues of self-determination, control over your life, having agency over your life, bodily integrity, these kinds of issues, that's what the notion of dignity is all about. And it's not only in other countries, it actually is also in the US. So thank you.
Thank you so much for that. Okay, so we're going to shift gears a little bit with Jesse and Katie, because, we've talked a lot about religion today, and we've talked a lot about law, and we haven't yet spent too much time on medicine and science, this sort of like third authoritative thing that's dictating how we're thinking through issues of reproductive rights. And so, Jesse, your paper for the symposium touches on this question of medical authority and determinations of life. And so I was hoping that you would tell us a little bit about how you've been thinking through these questions, the definitional contradictions that are emerging through the space of science and medicine. And then Katie, someone who thinks a lot about assisted reproduction, and this question of life sort of kind of always sort of hovering around, and somehow the assisted reproductive space has, walked around some of these debates and come out unfazed. But where do you see the overlaps and your thoughts on this as well? Thank you.
Yeah, thank you. Yes, I want to just talk a little bit about the paper that I wrote for the symposium, which I hate to disappoint you, but it is not about Ohio. That's all right. I'm happy to talk about Ohio, though, if folks want to, and maybe it'll come up on this panel. I've been very involved for quite a long time. Recently in litigation under our state constitution, and then in the campaign successful campaign to get a ballot, a reproductive freedom amendment added to our constitution. I want to talk about the idea of life and a right to life, and its relationship to this idea of medical authority. And we've been kind of talking all day about how there are these kind of two poles or two extremes kind of how we could understand life in this context. So one is just pure physiological existence, right? Just a very kind of narrow, bare bones concept of life. That's shared by all living organisms. And then this richer sense of like the good life with dignity, the things you need to live, chart your own life course, self-determination, and so on, right? And, I think it's fair to say that folks on the anti-abortion side tend to use, tend to lean on the narrower understanding of life, although they have also tended to sort of exploit this ambiguity, when it suits them. So, I think that, for example, the state's interest in potential life, right? We must be understanding life in a very narrow sense, right? Embryos don't have like interests or life plans yet or anything like that, right? They're talking about the state's interest in just creating a life, whatever that life might look like. In physiological existence. But then sometimes, they'll suggest that life has a broader meaning. They certainly trade on images of like happy children living fulfilled lives. And they also will suggest sometimes that the health and life exception that Roe recognized for post-viability abortions is just incredibly broad, and that doctors will, lean on this exception because it lets them perform abortions just, basically in any circumstances that the patient thinks it's necessary. And that's certainly not how providers, I think, any providers understand or understood that exception. So they kind of trade on this ambiguity. But I think like on the pro-choice side, there's been more, a tendency to be sort of stuck with a narrow understanding as well of what life means. And we've been talking all day about, how can we expand that? How can we broaden it in a legal sense, maybe among other, in the litigation arena, among other arenas. And I think one of the, because of the benefits we've been talking about all day. And my paper is just sort of suggesting that one real challenge with that is how abortion rights jurisprudence and also, litigation strategy has kind of painted itself a little bit into a corner because it's because of the very medicalized framing of abortion in abortion rights cases and how that's been carried through in litigation as well. And I just want to say, like, I'm not saying that this is a bad thing in general. It's something that I think, and I've argued elsewhere, has been a really beneficial and good framing of abortion rights as within a medical context. And also, I also think of myself as a litigator, so it's not, but it is a challenge, I think, uniquely because of this medical framing of life, which is particularly compatible with a narrow understanding of life. So And I just have a few thoughts about kind of why that is or how that comes about. And I think it's partly because we think of the right to life, or we think of life in the abortion context as being understood through the exception, the therapeutic exception framing. Most of the time, that's where it kind of appears in abortion case law. And I think, so one thing is that since Roe, that life exception has kind of always been understood in a fairly narrow sense, like a fairly narrow medical sense, right? It doesn't, contrary to what the anti-abortion folks like to say, it has not been understood to mean, doctors just go ahead whenever they feel like there's some basis for, that the patient can articulate for why it affects their life, right? It's been understood, right? And that's exactly what a lot of the litigation is about right now, is the concern that these are so narrow, if they are even comprehensible at all. Also, I think, we've kind of tended to understand, the understanding of the role of the physician in this process has changed over time. And again, in ways that are good and that make sense. So we think of kind of, contrary to the old model of medical care where the physician was kind of the, the fatherly figure who would tell you like, yes, you get an abortion. It's okay, right? You need one, you're deserving. And, taking all of these factors of the patient's life into account, now, doctors are kind of making the medical, scientific, health, physical health judgments, and the patients are bringing their values to the table, right? And that's the division of labor that we think is more appropriate now, right? The doctor shouldn't be making moral judgments about, other aspects of the patient's life. They're just looking at the sort of physical health questions, medical appropriateness in a narrow sense. And then also, I think as advocates, we've all had an incentive to frame medical expertise as technical, as narrow, as physiological, because that strengthens that expertise, right? It's more likely to be deferred to if it's somewhat, if it's narrow and technical and not accessible to the average person or to the average court. And it makes it harder, to refute with non-expertise, right? And so, anyway, I think in a way that's been one of the challenges with trying to broaden this concept of life, is that we've been also on the pro-choice side very committed to a narrow understanding of what that term means in the abortion context. And so just to briefly just sum up some thoughts about where we could go from here, it would be either, I guess, to sort of work on demedicalizing the understanding of abortion, or trying to expand the concept of medical authority beyond, right, which each of which has beyond the narrowly physical realm of physical health. And I think both of those have big challenges, but I'll stop talking now.
Thank you. Well, like everyone else, thank you for having me, Aziza, and thank you for leaving it to two attorneys to cover medicine today. I'm really drawing on my undergraduate degree in biochemistry, so that's where we're at for the medical part. Thank you, Jesse, for your paper. I want to say two things. One that will be more directly responsive to your paper, Jesse, and one that I hope will add to the discussion that's been going on today. The first is to just sort of take a step back and think about this tension we see not only in the abortion context, but in many other areas, particularly when we're talking about reproduction and healthcare, of this tension between medicalization and sort of autonomy enhancing, moving away from the doctor's gaze, as we think about it sometimes. But the tension that I see, particularly thinking from a reproductive justice lens, is that if we think about a move away from medicalization and sort of the pragmatism that medicalization, unless we also simultaneously overhaul the payment system of healthcare in the United States, that medicalization also facilitates access to the things that we need. So I'm thinking about in the context of abortion, I'm thinking about in the context of gender affirming care, I'm thinking about in the context of queer people making their families using assisted reproduction, that there's a way that medicalization is the mechanism by which things get paid for in this country that are essential to living the fulfilled life, as we are discussing sort of what that means, that, to be able to say,
I, a queer woman, will be able to go build my family how I want to and not have to jump through different hoops because the American Society of Reproductive Medicine decided in October that now I am by definition infertile, right? Thank you, ASRM, I think, right? Like, we can also unpack that for all of the ways that it's problematic to medicalize queer people, the entire movement that led from getting us out of the DSM. But so I just wanted to question and the way that you conclude in your essay, and as you mentioned now, that sort of like pros and cons, moving away from medicalization versus expanding the scope of what is medical. The deep pragmatism in me would think maybe medicalization, while in theory is bad if we're thinking about, in particular, those people most on the margins that are having trouble accessing the things that they need, that really, medicalization is a venue by which to get payment for things to realize the goals of their lives, might fall on favor of that option, of the two that you discuss in your paper. So I just want to put that on the table. The second thing that I was just going to say, that as we're talking about, religious justifications and other ways of defining life, that if we look carefully at, and as many in this room know, if we look carefully at the abortion restrictions, they tie back to gestation, and they tie back to definitions of pregnancy, which is established, if we rely on medicine, upon the implantation of an embryo into the wall of a uterus. So it is not the case that conception, while many abortion restrictions, if we read them carefully, talk about fertilization, talk about conception, in part because you can't figure out when conception happens. As I have many students in this room, they always remember, I give them a quiz about reproductive biology, they always remember that sperm lives inside it for 5 days inside a reproductive tract. So like, and ovulation happens within a 24-hour window. So they're like, and fertilization happens after ovulation. There's no way in the general course of things for cis hetero people making babies to know when fertilization occurs, to know when conception occurs, really. And so it is, and obviously in the context of IVF, we see that part of why that is part of the political economy, that is why abortion restrictions are actually not written to begin at conception, that they begin, that they tie back to gestation or tie back to a pregnant person, which I think if we're sort of talking about the theological integrity or honesty of these arguments, there's something different driving what's happening here that has a lot more to do with controlling pregnant people's body and autonomy. I'm not sure what work that adds to the discussion, except that it was something that's been itching in the back of my mind in this conversation. And the last thing that I'll just say too is that there is a growing, in the human rights discourse internationally as well as in the United States, a growing movement of a right to know someone's genetic origins that have implications for assisted reproduction and the selling of sperm and eggs in the United States, which is obviously a reproductive choice about whether or not someone wants to use sperm or eggs with a known identity person. This may seem far afield, but I want to add it to the conversation just to say that there are laws being put in place in this country to limit things like decision-making about sperm and eggs used that are justified on the basis of the right of the person that does not yet even exist. So when we're talking about the broader landscape of laws being put in place on the basis of a right to life or the right to a fetus, I mean, there are lots of different ways that I think call for intersectional, intermovement thinking to make sure that we are thinking carefully about the many different ways that people could be looking to restrict reproductive autonomy.
Thank you so much, Katie. Okay, so I'm gonna, start asking some follow-up questions, but I wanted to encourage my roundtable here to, ask each other questions too, and if people in the audience have questions, to raise your hands. But I'll start maybe by going back to Michelle, because it continues to connect to this theme of life. And I wanted to, Michelle, ask you, when we're having these contemporary conversations, are you in a good place to to hear me? Okay, all right. When we're having these contemporary conversations about a sort of legal set of rights that are going to be potentially given to embryos, the sort of ordaining of life to cells or to the fetus, and we have these other profound moments in our past that you've documented, where people have basically been declared people, where, with the 13th Amendment, for example, a sort of denial of personhood, and there's a transformation that occurs. I wanted to just hear you reflect a little bit on what we should be noticing from that prior moment. What should we be taking from that prior moment as we have these conversations today about sort of transformations in questions of who is a person and who is a life?
Well, it's such a great question, Aziza, because underlying all of this are sort of questions about who are the people that get surveilled, who are the people whose bodies are disproportionately policed. If we think about Texas's SB 8 law, coming into effect before the Dobbs decision, it says a lot about the sort of tensions between the state and federal government. One interesting parallel is to think about just even the effort to secede, right? So you have a sort of unified government that's going in a particular direction, and then you have states that say, well, we're not liking the way in which that government is going, so we're going to seek to secede. Those being southern states. It's interesting in drawing out the parallel here, because in Texas's SB 8, are you able to hear me?
The reproductive.
Aziza, can you hear me? I'm sorry, I heard a bit. I think you can hear me. So anyway, with the Texas SB 8 law, which weaponizes individuals to go after and find those who aid and abet an individual in the termination of a pregnancy, it was like a page right out of the fugitive slave laws. It's really stunning, and I said it at the time, and it was interesting. As soon as I said it, there's a place where I've published before, and there was an op-ed that was rejected by this particular publisher, it's sort of immediately thereafter, like on the day of SB 8 becoming law, saying, well, that just seemed a bit inflammatory. I think in the space since, we've been able to see these kind of parallels drawn out between that antebellum period and also the period of Jim Crow, which I've been calling a new Jane Crow, where literally people who need reproductive health care to save their lives, to save their fertility, or for the sake of their dignity in response to rape and incest, they're having to flee. And it reminds me of people having to flee those horrors of American slavery, where their bodies were put to certain tasks. They're sort of involuntarily used or coercively used, forcefully used for the benefit of others. And you see those parallels drawn out now with the kind of forced pregnancies. And you wonder, for whose benefit is this? Certainly not the individuals who would choose not to be pregnant. But it also reminds me, too, of the great punishments against people's bodies. We're in a country now that has an alarmingly high rate of maternal mortality and morbidity. The Supreme Court has acknowledged in Whole Woman's Health v. Hellerstedt that a person's 14 times more likely to die by carrying a pregnancy to term than by having an abortion. We know that nationally, Black women are 3.5 times more likely than their white counterparts to die carrying a pregnancy to term. And we know that's a national figure. It doesn't account for those anti-abortion states where in certain counties and communities, it may be 5 times, 10 times, 15 times more likely to die carrying a pregnancy to term than their white counterparts. So there are so many areas in which we can look to the past that helps us to inform what's happening today. And I think the real mistake would be thinking that what's happening today is something in the abstract, that it doesn't actually have its vestiges or threads in the past. And I'll give one last example of that. And that is in thinking about the way in which the sort of replacement theory is being actually specifically used and talked about these days. How we actually get the criminalization of abortion to begin with is actually this concern. It's a multitude of things that come up all at once in this kind of perfect storm. But one aspect of it, led by the anti-abortion physicians who are actually not so concerned about abortion. I think that they were far more concerned about getting women out of reproductive health care, and that abortion became a tool to do so because abortion had not been criminalized. But part of the rhetoric that they used, the Horatio Storrs, Joseph DeLees, et cetera, was that, white women needed to spread their loins and go east, south, north, and west. And this real concern that given the march of the Civil War coming, that there would be this browning of America if Black people were freed from slavery. So there's so many threads from the past, I think, that help to inform today. And I haven't even talked about criminalization, but I'll turn it back over to you.
It's very, very helpful. I wanted to ask a second question, sort of, thinking about Serena and Mary, and also bring you, Christina, into the conversation about social movements. And I just wanted to, think a little bit about, Serena, in your case, I think the invocation of sort of life as part of, seeing women's lives, sort of pregnant people's lives as part of a sort of life of a community, and how this ties back to the sort of proposals, or if it ties back, to these sort of pre-reproductive justice movement type of organizing that was going on in the context of welfare, for example. And I just wonder if there are any threads there that connect a sort of pre-formal declaration of reproductive justice rights movement, that sort of welfarist reproductive rights movement, to the movement that we're in now, along these lines. And Christina, I was hoping you could say a little bit more about what Catholic feminist ethics is in this moment, because I was thinking about, and you kind of gave a warning about religious exemptions, and earlier today we were talking about the use of religious exemptions for access, in the sense of being able to say, I'm a particular sect of Judaism, and so therefore I can claim a religious exemption. You sort of warned us about that, and I wanted you to, on one hand, talk about the double-sidedness, but on the other hand, if you could put Catholic feminist ethicists in context for us, like inside of the Catholic Church, inside of sort of the way Catholic doctrine and activism might be developing in this particular moment, and also vis-a-vis this broader question of sort of, is this a theocracy that's coming, that's sort of animating a lot of the fears right now, that the current legal frameworks that are being proposed are actually, and we heard this morning, are actually the product of a particular type of Christian nationalist project, as opposed to a sort of secularist sort of belief in life or something. And then Mary, I just wanted to ask you if you could say a little bit more about the connection that you drew out really briefly for us between personhood and incarceration. I wasn't sure I fully got that, and so I just wanted to give you an opportunity to say a little bit more about that, because I think it's been important to your current project. Thank you. I don't know, Serena, if you want to start.
Sure. Thank you. This has been so generative. So one thing that I think is a lesson that we can draw, if there is such a thing, from the history of these proto-reproductive justice movements, is in thinking more broadly about life. In particular, I think in the present day, at least, many anti-abortion folks, refer to themselves as pro-life. And we really have an opportunity, I think, to, as we've talked about throughout the day, emphasize the correlation between states that ban abortion and states that provide the most meager social supports to their neediest citizens, right? And I think, there are actually, though some of these principles of human rights and of welfare rights seem sort of foreign to U.S. domestic law and certainly have not been embraced by courts oftentimes, we do actually, I think, have doctrinal tools at our disposal to do that. And so, some of them are left over from this earlier period, but sort of what it was occurring to me as folks were talking about various, constitutional provisions we can rely upon and so forth, that whatever provision we rely upon, often what we're trying to do is to get courts to scrutinize abortion restrictions. And one of the ways to do that we've already talked about to some degree today is to, ask, well, what would a state do if it truly valued life and truly valued the lives of pregnant people and children and people who've already been born. And the truth is, as we've talked about, that they wouldn't jump to criminalizing people for having abortions, but they might provide universal health care and increase access to contraception and comprehensive sex education, and they might increase protections for pregnant workers and workers who have caregiving responsibilities. And all of those ideas, I think, are ones that that harken back to some of these earlier proto-reproductive justice movements that are really trying to get at what do individuals and families and communities need to raise their families in, as the reproductive justice movement later put it, in safe and sustainable communities.
Mm-hmm. Yeah, and that's precisely where I see the connection to this idea of Catholic feminist ethics. I had earlier a BU law grad in my reproductive rights class, a BU law grad, Erica Bakayaki, who is a sort of, I guess, becoming a leading. She's a leading voice now on sort of this Catholic feminist position that sort of tries to bridge the divide, it seems, from like pro-welfare, pro-life, and it seems like you're taking a slightly different position here, Christina, but maybe not. Maybe I didn't fully understand, but I'm curious to understand how all these different versions of Catholic feminism are sitting in relationship to each other, and sort of the ecosystem of movement politics that are happening at this moment.
Okay, I'll try.
Okay.
All right. So I think that your student is probably
Oh, she's not my student. She's
okay.
Yeah, a grad of the law school.
So she's really representing what I would call the Joseph Cardinal Bernardin consistent ethic of life position, which is that you promote support for a full and robust, flourishing life for people at all stages, from conception, realizing this is a problematic term, to natural death, which means no euthanasia, but also no prolongation, right? And so you say that, all right, life in itself is a platform. The existence of biological life is the platform from which we can build this flourishing life. And so, first of all, we need to protect that existence of life at all stages, so from conception. But secondly, that has to go with strong social policy, really robust minimum wage laws, housing policy, child care, right? We have living wages. We have to do all of these wraparound kinds of policies in order to ensure that, first of all, people actually can freely raise children, and this is one of the arguments of the reproductive justice movement, right? Not just freedom from raising children and bearing children, but freedom to do so. So that she would be arguing for that whole complex of things. The question is whether you think that before that whole complex of things, of supports exists, we still need access to abortion, right? And that would cause a divide among some Catholic feminists, right? Because you look around and you say, well, that's great, we've been arguing for it, but actually neoliberalism went in, and this is the other elephant in the room, I think. I think if you track, I'm not a historian, but I think if you track neoliberal economic policy and the difficulty of raising children in this country and the decline of really robust social policy, they will go together, right? And because, as we've mentioned, the whole point of when it was called Aid for Families with Dependent Children, the whole point was that an adult could stay home, right? Not that a parent was being lazy by not working, right? The whole point was that someone could stay home and provide intimate care for children. That went out the window 40 years or more ago, right? And so we have a whole different, sorry, I've gotten off track. But my point is that we're nowhere near that society, right? And what do we do about that? And so I think for some people that says, well, we need an out, right? Because we need those choices. There is some Christian nationalism behind some people's pro-life stances. whether we're going to have a theocracy depends on whether wealthy, conservative, religiously minded evangelical Protestants and Catholics manage to use their money politically in order to stack courts and legislatures, right? Because I think that it's less about the average voter and more about who has money. I think that religious, liberal, progressive sorts of people tend to give a lot of money to direct service organizations, right? To Planned Parenthood, to their local food pantry, to whatever, right? To direct service. That's not what conservatives do. They give large amounts. They take all their money and they give it to some sort of foundation or think tank, right? That is writing bills for people to take to their legislatures. And there's a different spending pattern there, and I think that is one of the challenges. So theocratic maybe, but not by church leaders.
Yeah.
Right?
Right. Yeah, that makes a lot of sense. Yeah, and Mary, do you want to? You can. I mean, if you want to keep this line of conversation going, or take us back to what you had said earlier, either one.
Sure. I mean, I can go back to what I said earlier. I mean, one of the questions I think that's interesting is, well, one thing that's kind of an interesting jumping off point is there are a lot of polls suggesting that there's a subset of Americans who are deeply opposed to criminalizing abortion and support abortion access, but who think life begins at conception, or who think that fetal rights exist or something. And so it may be that these people just aren't understanding the question, or it may be that there's something there. And one of the questions that interested me when I was writing the book was, if in South Korea or if in Germany, there's some kind of constitutional recognition of fetal life that doesn't ipso facto lead to criminalization, how did we end up here with a regime that does? And it's become more carceral after Dobbs than it was before, right? I mean, it's interesting if you look at pre-Roe criminal laws, they all authorize criminal punishment, but nothing of the kind of magnitude we see in places like Alabama and Texas today. So I think that the kind of happy news about this history is that it seems that the development of something as carceral as we have now was pretty contingent, right? It wasn't intrinsic to the idea that, you think there's a right to life for pregnant people or really for fetuses either. I mean, that didn't follow. There were a lot of people in the anti-abortion movement who were willing to experiment with other ideas. And we occasionally see this emerging after Dobbs, right? There are pregnant people who say, well, if a fetus is a person, I'm going to drive in the HOV lane. And if a fetus is a person and the state of Texas didn't allow me as a prison guard to leave my station and caused me to have an unwanted stillbirth, I'm going to sue them because that was an interest that the state says is a real one. So I think the sort of short version of how it became carceral is a combination of the anti-abortion movement's partnership with the Republican Party, its partnership with the conservative legal movement, and its partnership with the Christian legal movement. Earlier anti-abortion advocates, many of whom actually were Catholic, were often trying to situate what personhood was vis-a-vis other suspect classifications like race, and were essentially arguing that they were trying to identify the next vulnerable group, and they would say, discrimination on the basis of, residence in the womb. And then over time, the more the movement became financially and politically dependent on the GOP, and the more the GOP in the Reagan years oversaw a pretty broad expansion of the carceral state, the more the movement had to kind of retool its arguments. And I think also significantly, the less plausible it came to seem that the Supreme Court would recognize a new suspect classification. So then instead you began to see the movement doing what we see now, which is to write personhood into other areas of the law, some of which Michelle has studied, like sponsoring prosecutions of pregnant drug users or people with substance abuse issues during pregnancy. You saw them beginning to essentially frame the fetus not as, yet another marginalized group that needs protection, the theory at least being that we care about marginalized groups and want to protect them, but rather as like a victim of violent crime, right? Just sort of like the white majority that's being victimized, as Reagan would have put it, by either people receiving welfare or by criminals who are often imagined to be something other than white too. At the same time, right, these arguments about victimhood and punishment resonated with the Federalist Society, which wanted to take an approach centered on what it called history, as opposed to some of the more kind of Warren era constitutional approaches earlier Catholic lawyers had taken. The Christian legal movement, which has become a bigger and bigger part of the anti-abortion movement in the years since, I think also resonates pretty strongly with a punitive approach. This is more true as the anti-abortion movement has moved, generally speaking, south and to the right? So disproportionately now, the average anti-abortion voter is a Trump supporting evangelical in the South. That wouldn't have been true historically. So I think our vision of when we say a right to life in America, when you usually think about what an anti-abortion person would mean by that, you're thinking about something that's a byproduct of decades of social movement struggle. You're not thinking about something that necessarily follows from the idea of thinking that life in the womb has value. So Greer Donley and others, Jill Lenz, have written about how we might want to reconcile the idea that there are people with wanted pregnancies who very much see those pregnancies as having value or as being persons, and the idea that we don't want to limit access to abortion as much as we don't want to limit access to other reproductive health services. And I don't think the history obviously points to a way to do that, but it makes clear that the sort of weird configuration we have now, which is that personhood equals fetal rights and fetal rights equals incarceration, is a kind of not inevitable, not natural contingent, and something we can hopefully move beyond.
You know, your sort of discussion about the rise of sort of carceral approaches in the reproductive health context as it sort of stems from Reagan, of course, reminds me of and sort of helps me connect what Mary was saying to what you all were saying earlier, Jesse and Katie, which is that, you know, of course, that didn't just get legitimation off of the sort of that project of incarcerating pregnant women for drug use, for example, wasn't just based on sort of a set of moral philosophical ideas. People really mobilized science. You know, we had these bad studies on small n studies about the supposed quote unquote crack baby epidemic, and these studies were used inside of courts to basically generate a whole bunch of expertise legitimating the studies and allowing for a particular law reform projects that then instantiates this particular notion of life inside of law. And it has me again thinking about your paper, Jesse, and about your comment, Katie, about and really to sort of, if you guys could reflect on how this more iterative relationship that's existing between medical expertise and law, so that it's not just like doctors are over here doing something and lawyers are over here borrowing those ideas, but actually certain ideas are being deeply legitimated through our Supreme Court jurisprudence around questions of life, for example, or certain claims, sometimes totally unsubstantiated. Like if you look at some of the briefs filed in Dobbs that talk about, you know, when does life, from conservative organizations about life, they really don't have any citations. They just say like life begins at this particular moment, science says life begins at, but there's no citations to it, and then the idea gets kind of sort of captured in the abstract, but is sort of legitimated in the broader political environment we're in. And it has all these consequences, right? And this is what Katie's, you know, your presumptive infertile point, you know, like that all queer people are presumptively infertile. On one hand, it's sort of a state, it's a policy statement that sort of requires a sort of legitimacy, but it's also to get medical care, you know what I mean? Because the presumptive infertility, as awful as it sounds, is going to allow people to go over the hurdles being put into place by health insurance, essentially, that say, oh no, you're not actually presumptively infertile. You have to go now prove to us that you are infertile, which is an impossible task if, you know, in some cases. So,
or you just have to do things.
Right.
Yeah.
Right.
Yeah. That's a whole other conversation.
So you know, let me just throw it back to you guys.
Jesse and Katie. That question, just
yeah, of course.
And that would just simply be adding to that question the trope that's used, right? So the expedience of using vulnerable people to carry out those kinds of agendas, because it's not in the abstract the way in which the so-called crack mom gets trapped, right? She's vulnerable, she's poor, and she's a woman of color. She's more likely to be Black, in this way in which science gets distorted. If you think about eugenics, it's poor, you know, 1927, right? It's Carrie Buck, poor pregnant, raped white girl, right? Virginia's rounding up not wealthy elites. Virginia is specifically targeting very poor, vulnerable people who lack political, economic clout in order to instantiate this kind of pattern. And I think that that's a kind of important precursor to how we think about how science gets legitimized when it's being used towards a very negative, unethical end.
Yeah, and mobilized at will, like we all know the Carhartt, the perfect Carhartt example, that abortion causes regret. But anyways, go ahead.
Yeah, no, and I was just going to also kind of bring it to today in terms of the case that's pending before the U.S. Supreme Court right now around whether the abortion medication mifepristone, right, should have ever been approved, and the mobilization of junk science and the studies that were relied on that were actually just withdrawn, right, or retracted by the journal that published them, to say that mifepristone's unsafe, it all within this context of, right, very politicized distrust or trust of medicine, of scientific expertise and medicine, and when do we trust it and when don't we, and is it just another sort of political tool? And then also, some of the things that Mary was saying, got me thinking about a couple of things kind of along the line of bringing this back to the criminalization, which is just, the fact that abortion bans have criminal penalties is also, I assume, largely a vestige of the fact that they did in the 19th century, right? And some of those are actually the same laws, right? So I think going back to that criminalization campaign of the 19th century and the role of medical authority as being the sort of safety valve that was much broader in the 19th century than it was now, has brought us to this place where, essentially those same laws are in effect, but medical authority is understood much more narrowly, and, criminal penalties are, worse and more enforceable, and so that's why pregnant people have significantly fewer rights now than they did under those 19th century bans, even, right? And then I just want to say one other thing in this kind of this goes in a little bit of a different direction, but in this whole personhood discussion is how for all the right to life, embrace of fetal and embryonic personhood, how very much it has failed so far as a concept. Nobody buys it. I really feel like nobody buys it, and it's it failed in Mississippi in 2011 or whenever that was. It's failed repeatedly, and I think, part of in the post-Dobbs reality, especially now, it just feels like such an abstraction in comparison to everybody who knows somebody who's had something go wrong in a pregnancy or some sort of experience, right? Including with later abortion, which used to always be kind of the third rail of the pro-choice movement, and now is impossible for anti-abortion folks to really even gain traction on, and so where the personhood would seem the most evident. So anyway, I think that's a really interesting kind of dynamic in terms of this personhood debate post-Dobbs, but sorry if that took things away from where you were going.
No, I'm happy to do Q&A. I want to hear what
Oh yeah, great. Okay, and Erin, I didn't ask you a question, but maybe we'll see about Q&A.
Oh, I'm sorry, I didn't mean to.
Oh, no, it's okay, great. Yeah, we'll open it up.
Hi, my name is Julia. I'm a student at Northeastern and a student of Professor Krashel's. I've been thinking a lot of the idea, we've talked about it in class obviously, but of the demedicalization, which I think a lot of it has happened around self-managed abortion and this idea of making it more accessible to folks, while at the same time we're seeing states like Indiana, South Carolina enact either implicit or explicit telehealth bans for medication abortion, so either by requiring in-person visits or by explicitly outlawing medication abortion or the use of it, and kind of this tension that we see as lawyers between demedicalization in order to increase access via SMA versus the necessary, the way that medicalization has always been used in order to decrease people's access to abortion, and kind of how folks are reconciling that tension in maybe your own work.
I don't know. I guess that's me. Yeah, I think, I've been thinking about this a lot too, and I'm not sure I have a really good answer to it, because I think there is all sorts of kind of ironies even in that, right? So on the one hand, we talk about self-managed abortion as demedicalizing abortion, yet, you know, I mean, what we're talking about is medicine that is approved by the FDA, and that's what we want people to have, right, and to take. And, you know, so we're really talking about just sort of taking it outside of the formal clinical setting, right, which is that really even demedicalizing it? Like, you know, and then you think about, like, again, like the real need for medical care and medical expertise in these in the very different context of medical exceptions, and, you know, which is often on the like later end of abortions that are very you know, more difficult and complicated medically, and so you know, I think that the possibility of completely taking things out of the medical system is not, you know, I mean, it's problematic, right? It's just like, it's not a realistic possibility. And at the same time, it seems like, you know, we're setting up this system where there's always some source of authority, right? There's either medical authority or the criminal law authority, or there's the church authority, right? But we've got to have somebody telling people what they can do with their pregnant people, what they can do with their bodies, because, you know, there can't just be, like, there's no such thing as sort of a right that isn't subject to someone else's say-so, which is sort of, I don't know, where we seem to be, and I'm not sure what the way out of that is.
Thank you. Michael Ulrich here at BU. So I know a conference built around the right to life is going to focus a lot on rights, but I'm curious about the state's interest, and I think it touches on a lot of the stuff that's been discussed here, but from the other side, right? A lot of these discussions, to what extent can they be used to push back against alleged or even pushing courts to investigate at all why the state is doing something, right? I mean, you know, rights are a barrier to government action, but at least as far as I know, and there's smarter people here who can tell me I'm wrong, like, the government can't just pass laws for no reason, right? It has to be connected to some interest, right? Even rational basis is there a legitimate interest, right? Which also then means, is there some rational reason to think that this is connected to that interest in any way? And, you know, it just seems to me like if we could get courts to look at this to some extent, that it's no longer a fundamental right part, you know, that the importance of that can be diminished to some extent, right? I mean, you know, is this law actually going to help the infants in Mississippi, which has the worst infant mortality rate? I mean, infant mortality in the South, especially for, you know, infants of color, right, and for infants born to black women, like Mississippi, is this law going to help that at all? Or is it going to continue to make worse that you are terrible at doing this, right? And so in all of the other places, right, is it better to lock up this pregnant woman for the potential life that you are asserting an interest for, or is there some other reason to think that that's going to make it worse for the potential life? So I just don't know if that's something that we need to be thinking about too.
Sure. So, I mean, I think Mississippi is a great example of the potential for that kind of argument, and one that has an argument that has been had in Mississippi, and I'm sure many other state legislatures, where in Mississippi it's particularly stark. You have, frankly, a lot of white male Republican lawmakers arguing that Mississippi was going to be the most pro-life state in the country if it passed these abortion bans. And black, female, and some male lawmakers arguing back, well, gee, if you're really concerned about our lives, why don't you expand Medicaid? Why don't you use free federal funds that are available for child care and for health care? Why don't you actually use them rather than throwing them away because you don't believe in big government, et cetera? So I think, I think in Mississippi, unfortunately, that hasn't been politically a strategy that has worked for reasons that have to do in part with, you know, the degree to which many of these legislatures are extremely gerrymandered, and folks who are making these arguments are outnumbered. But I think getting back to kind of the question of doctrine, the doctrines that we have, you know, scrutinize the link between means and ends, right? And it's exactly what you're talking about, is thinking about if the state really wanted to do the things it says it's going to do, is this the way that they're going to realistically achieve that?
Oh, yeah, Diana. Yeah.
I was just going to say the recent Pennsylvania decision is really helpful because they, under the equal, not the ERA, not the sex discrimination, which gets strict scrutiny, but under the equal protection claims that were put forward, they do a very close analysis of why there is a much closer means ends analysis under Pennsylvania's constitution, and it's not the kind of rational basis that's been the default, and it asks the question you're asking. And I thought it was helpful because it wasn't, you didn't have to prove pretext, which is what we always felt like, these are clearly pretexts and why, no court will admit it. But this didn't go, right, it didn't go that route. So I would just point to that decision as a helpful one to look at.
Professor Ulrich, I welcome, can I? Go
ahead.
Yeah, so I mean, that is the Mississippi case, right? So if you look at Justice Carlton Reeves' district court opinion allowing for the injunction, he directly challenges Mississippi on this question. Mississippi said that it was enacting its abortion bans for the protection of the health and safety of women who could become pregnant in that state. They were not saying such with regard to pregnant people, but women. And Judge Carlton Reeves called them directly out on that through a series of footnotes where he said, well, Mississippi, how could that be true? You've actually never had a history of really investing in women generally. And in fact, the history that you have on display is one that has been very hostile towards the interest and the concerns of women, particularly that of Black women. And he cited, for example, the Mississippi appendectomies, referencing Fannie Lou Hamer, et cetera. But then this raises another issue about our courts. Are our courts today what we expect our courts to be? I mean, it used to be probably a decade ago that we would frown upon someone saying, well, the court, Supreme Court really engages in outcome determinative type of adjudicating. Although today we have a former president who is being very vocal about, I put justices on the Supreme Court and those in lower federal courts for a very specific reason. This is what I've sought for them to do. They follow, they listen to me, which is incredibly unhelpful in a backdrop where Americans have expressed distrust of America's courts, particularly the Supreme Court, and has expressed the most distrust of the Supreme Court since there have been the kind of polling on those matters. And so it's a bit of a split, isn't it? On one hand, what courts could do, should do, and on the other hand, what can we be expecting of courts today? And I think that may be very dependent, unfortunately, about what state the court is, or who is elected, or who has been nominated and is now serving as a federal judge. And that is really unfortunate.
So much. Katie wanted to say something, Martha, Linda?
I was just going to thank Professor Ulrich for giving me this chance to smile for a minute, thinking nostalgically about whole women's health, the decision that seemed to care about empirical evidence supporting claims made about protecting women's health. But even I think that, something that we sort of danced around, I think, in the First Amendment panel a little bit was the idea of a very secular justification that I think can convincingly be put forward by states about this more sort of consequentialist frame of thinking about the way that protecting life informs the way that we think about treating one another and respecting life, and sort of the expressive force of the law that was the justification for things like fetal remains cases, and the way that the federal court, even in the hot second when whole women's health was the law of the land, upheld fetal remains laws insofar as it was much more difficult to sort of call the bluff of a state legislature that was saying, there's this expressive thing that we're doing here in talking about respect for life, and it's important for us, and our state interest is in talking about respect for life in the way that this sort of consequentialist frame is deployed. And so I don't know that I'm convinced that there is a there and probing more at even with a better sort of jurisprudential landscape in our whole women's health, that wasn't sticking. I'm deeply skeptical that today it would, at least in the federal court.
And I just want to interject with one little thing too. The conversation between Michael, who works on the Second Amendment, and Katie is also reminding me that we have Aaron here partly because you have this experience thinking about environmental litigation and the question of life as it's come up in the environmental litigation. So, we're sort of triangulating here between all the different places where life is coming up. And so if you wanted, no, that was sort of a pop question there, but if you, at any point want to weigh in with that, would love that, yeah.
I've been thinking a lot about that. The environmental context where I do a lot of work also is actually kind of problematic here. It's really helpful because, again, it helps us think about sort of the totality of sort of human experience and how our experiences are interconnected, and if you take away a right here, it impacts rights there, and all that kind of stuff. So the framing of it is really nice. One of the things that's a couple of sort of movements that are going on in the environmental sort of human rights world right now. One is about rights of nature and the idea of non-human rights. And it's a wonderful thing if you're an environmentalist to be thinking about expanding rights and expanding rights beyond personhood and thinking about all that, and you can see how it can start to get a little problematic. And even more problematically is children, bringing all like this climate litigation that we're seeing in the U.S. and also around the world, and a lot of that is framed not just as children's rights, which would be one thing, but also as the rights of future generations. And all of my friends on the environmental side are really, really into this idea of future generations having rights that we have to protect, and that I'll just leave it right there.
The rights of sperm. Yeah.
And that if you're serious about future generations, like 7 generations down, we have to have sustainability so that the planet is there for our, grandchildren and their grandchildren who aren't even born yet and everything. And it is really problematic. And when I've raised it with people, I've not heard a good answer to it. It's really just sort of, these people are having this conversation and it's great, and then the implications of it here are not as it's difficult.
This is a pointless point for you lawyers. So I want to agree with you. I was thinking about the future generations, right? And we may as societies need to detach the idea of rights from the idea of personhood. And we also need to realize that at some point, our definition of a person is always arbitrary, and I'm thinking back to the discussions of religion, norms, and the law earlier, right? Because to say that that a human life becomes a person at birth is arbitrary, especially because the amount of autonomy a 1-day-old can exercise is fairly limited, right? As we all know. So there is for those of you who might be interested, there's a very interesting Lutheran theologian, Margaret Kamitska, who has written on how life in utero is human and has immense value and does not have personal rights yet. And this is what makes an abortion decision weighty. Otherwise, an abortion decision would not be weighty, right? So she is wanting to pull apart this idea of when a valuable human life exists and when a person with rights, who has rights larger than the pregnant person exists. Mm-hmm. So this question of when you all declare that a person is a person with legal rights is a very interesting question, and we may have to separate the question of rights from the question of personhood, which will make it even more complicated.
Mm-hmm. Yeah.
Can I just add something quickly to that, which is, I think that's really brilliant and useful and thoughtful, and also even just rights are not a package deal, right? So some things may have some rights and some things may have other rights, and we shouldn't. We should welcome the nuances and the difficulties of that, and sort of use it in the ways that we think are, most useful.
I think we have to wrap up, but I'm sorry, Martha, but also, before we do, I just wanted to thank our Dean, Angela Onawachi-Willig, who we thanked earlier but wasn't here and is now here. I think somewhere in the back. Thank you for all your support. And with that, we'll close the future. Future generation.
Thank you very much.